Andrea? I'm not sure if we checked in with it. Is there any Andrea Lee here?
No.
On the record in the matter of John Addis versus Andrea Lee, 17-03577 GC. Appearance, please.
Good morning, Your Honor. John Hintz appearing for the plaintiff, John Addis.
So today was the date that was set for a show cause, a motion to show cause. No one has appeared on behalf of Andrea Lee. Did you want a warrant to issue?
Yes, Your Honor. Originally we were here on July 24th, where the defendant had been personally served. The defendant did not appear. We scheduled the show cause for today, and the defendant is not here. And so we respectfully ask the court for permission for a bench warrant. The judgment amount is $7,900.
Bond in the amount of 10%.
Thank you, Your Honor. I will prepare that and submit it to the court. Thank you.
Thank you. You're all set.
Thank you. Have a good day.
You're welcome. Ava and Michael Sharp here. Yeah, they're in the break room. We have a resolution. So they have a resolution? Why not? It's still. On the record in the matter of Hunter Financial versus Eva Sharp and Michael Sharp, 24-06315, counsel appearance.
Morning, Your Honor. Nicole Westlake appearing on behalf of the plaintiff, P80717.
Okay, and I see Michael and Eva Sharp present via Zoom. Today was the date set for pretrial on a general civil matter. My understanding is that you all come to resolution.
Yes, it is. Well, I'm just waiting for the signed paperwork back, and then we're going to file a conditional dismissal.
Okay. Mr. and Mrs. Sharp, do you have any questions today?
No, I don't. Thank you.
Okay, any additional matters for the record, counsel?
No, Your Honor.
You're all set.
Thank you.
Thank you.
Thank you.
I did, Mr. Arkaniki come from this, Mr. Arkaniki, did you meet with Katie Kelly or did she not appear?
I don't know if she's here, Your Honor.
No one's here on behalf of Katie Kelly? Okay, you want a motion to show cause?
Yes, Richard.
I'll note that you'll file that paperwork.
Thank you.
Thank you. Mr. and Ms. Sharp, you're free to go.
Okay, thank you.
Thank you.
Wells and Cox. Right.
First two. Oh, there it is. This is just a regular hearing. On the record in the matter of Briarcliff Apartments versus Darien Wells, 24-03670, council appearance. Is council here?
No.
Have you seen the attorney for Briarcliff here?
She said she would check into it.
Mr. Wells, hang tight. I think the attorney must be in another courtroom. On the record in the matter of the people of the state of Michigan versus Jada Otis, file number 24-02219, council appearance.
Good morning, Your Honor. Case Markarian, appearing on behalf of the people. First, making a motion to practice under Michigan Court Rule number 8.120.
The Attorney Luke Goodrich from the Public Defender's Office here to represent Ms. Otis, who's seated to my right today.
Okay, today is the second day of the continuation of our trial. I know that we were going to continue some testimony today.
Yes.
Okay, and so did you want to block your client outside the?
No, Your Honor, we are ready to call. We're going to call Ms. Otis at this time.
I recognize that, but I want to know if you want to block her, then we call the jury
We don't need to.
about her rights.
Well, all right, we certainly can.
Thank you.
We're just going to have you ask the vote.
You can take the witness
All right.
stand. Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Thank you. You can have a seat, ma'am. Okay, you understand, ma'am, that you are being charged in this matter. This is a criminal prosecution, correct? Is that a yes? Yes. Okay, you understand that you have the right to remain silent. Anything that you say can be used against you. Okay, you understand that by testifying, you give up that right, and you also expose yourself to being cross-examined by the prosecution, and they can ask you questions now that you have, if you're waiving your right to be silent. You understand that? Yes. Is anybody threatening you to get you to waive your right to silence today? No, ma'am. Is there any promises to induce you to waive your right to silence? No. Okay, so you're testifying voluntarily? Yes. Okay, any other questions?
No, Your Honor.
Okay, we can bring the jury in.
Your Honor, before we bring the jury in, I just have a matter I wanted to bring to the court's attention. I feel obligated to as an officer of the court, although I know there's not much we can probably do about it at this stage. I did give Mr. Goodrich a heads up. Yesterday, when we were leaving the trial, I had communicated with both the victim and her mother. Her mother was present in the courtroom all day. She's not a witness to this case. While I was communicating with them, just generally speaking about what they thought about the case and how it was going, her mother brought to my attention that throughout the day when she was going down the hallway, she saw both witnesses, Kimberly Hinton and Teresiah Edwards, on their phones watching the YouTube live stream of the trial throughout the entire day. I know there's a sequestration order in effect, and these are simply just allegations at this point that I'm not sure what can be substantiated on, Your Honor. I just wanted to bring it to the court's attention.
How does she know what they were watching?
Apparently, she saw it on their phone.
Oh, she got close enough to see their phone?
Apparently, they were sitting on the benches near each other. I don't really know what can be substantiated. I just, as an officer, I checked with my bosses. As an officer before we felt the need to at least bring it to Your Honor's attention.
Thank you for noting that.
And I would just say that I personally did not see that, and I was completely unaware of that if it did.
Sounds good. I don't know where they were located.
I did see them seated on the benches out here on phones with earbuds in for most of the day, Your Honor. I hope that they were just watching Netflix, though. I didn't assume anything.
You know, I never looked at the phone, to be perfectly honest.
I would agree, and I can walk past you and I could not tell you what you were watching on your phone unless I intentionally got into your business. If in fact that was the case, I would have hoped that she would have reported that to you sooner versus today.
Yes, sir. It
Or
was
at the end of the
yesterday.
day, at the end of the day, because then it could have been addressed.
Yes, sir.
But to sit outside the courtroom is violating an order, that'd be weird, and grossly inappropriate. So nonetheless, thank you for noting that. That's noted on the record. Any other preliminary matters before we bring the jury?
There you are. People are ready to proceed. Thank you.
All rise. Okay, you can be seated. For being kindly returning today. We have a witness under oath. You can proceed to question your witness.
Thank you, Your Honor. Miss Otis, let's start with some of your relationships to other people in this case. How do you know Nequela Powell?
I know my friend was through Terraside.
And how do you know Terraside?
We were friends in high school.
How long ago were you in high school?
I graduated in 2022, so probably about 3 years ago is when I graduated, but I've known her since my 9th grade year.
Okay, so you've known her quite a 7, 8 years, something like
Yeah,
that.
yes.
And how do you know Miss Hinton in this?
I know her through Terraside and Quailish, kind of was introduced to me through them.
Over the course of the last year, have you spent a substantial amount of time with the three of them?
Yes, every day.
Okay, and at some point, did you become familiar with Nequela Powell's dating situation?
Semi, yes, not all the way, but a little bit.
Okay, what was your understanding?
From my understanding was she was in a relationship with Mark. I don't know around what time that relationship happened or when it started, but I do know that she was in a relationship.
Okay, and as part of this relationship, did you ever learn about any kind of drama that arose out of this relationship?
Yes.
Okay, what did you learn about?
So basically, Miss Smith is the mother of Mark's children, and she didn't really like that Mark was going off dating other people, so she kind of went on, social media and was antagonizing.
When you say on social media, what type of social media are you referring to?
Facebook, Snapchat, it was a new platform every day. It was something new every day.
Now, are these things that you saw or are these things that you were just told about?
No, this is things that I saw personally.
Okay, well, I mean, what did you see personally?
So there would be posts about like her car,
I'm
her
sorry, when you say
Miss Powell's car.
Powell's.
There'd be posts about Miss Powell's car, her home, the way she is as a mother, just little like jabs at Miss Powell like every day.
Okay. And to your knowledge, did Miss Powell respond at all to these?
At first, no, she did not.
Okay, well, did that change at some point?
It did, yes.
Okay. When did that change?
It changed when Miss Smith took it upon herself to text Miss Powell her address. So basically she went online and figured out Miss Powell's address by like looking up her name or something like that. And she texted to Miss Powell basically saying like, oh, I know where you live and I'm gonna pull up. And she actually did come to her house.
Well, how do you know that? How do you know that she did pull up like that?
Well, I can say one of the times it was told to be by Quayla's Miss Powell, but Quayla also has a ring camera.
Okay, did you,
Objection, Your Honor. At this point, I got to object to hearsay. I think all the information she learned, she just said she was told to her by Maxwell.
Your Honor, we will withdraw that question and slightly alter that. a little bit.
Objection sustained.
Move to strike. The answer.
Stricken.
Thank you.
Did you watch Ring videos?
No, I didn't.
So you didn't personally see it?
No.
What else did you learn about this ongoing disagreement between Miss Powell and Miss Smith?
Honestly, it was really just a lot of like cattiness back and forth for a minute. It really didn't get like serious to the point where it was like an altercation or anything like that until she started like, you know, sending addresses and stuff like that.
Well, did you get involved in this?
No,
Okay.
it never had anything to do with me.
Well, we heard testimony from Ms. Smith yesterday that that you had sent some messages that she received messages under the name Jada. Did you send those messages to her?
It did come off my account, yes, but it was not me that sent the messages.
Well, who did send those messages?
It was Miss Powell. She was texting, you know, her off of my account, Miss Edwards' account. You know, she didn't want to fight the girl. She did.
Why was she using your account instead of her own?
Miss Smith wasn't texting Quayla back off of her account.
Okay,
She
so,
wasn't responding to Quayla off of her.
so after she quit responding to Naquela's account, Naquela started using your account and Miss Edwards' account?
That is true, yes.
Okay, to try to get her to respond.
Is that a yes?
Yes.
Okay, well, moving along here, why don't we head toward July 26th? That's the day of the allegations in this case here. Can you kind of explain to me what went on? How did this day begin?
The day was really just like a normal day. Kim ended up going to Terraside's house, which is where I was living at the time being. She went over there. She was showing us her tattoo that she had got on her leg. I honestly don't know at what point. I don't know at what point when it turned into like a big, like, oh, we're finna go over there and fight her. All we know is Quayla was mad. She's seen something on her phone.
Wasn't Naquela there?
At Terraside's?
Yes.
Yes, we were all there together.
Okay, what time of day are we talking about?
It was like later afternoon, like right around the time the sun would like start to set, you know, yeah.
Okay.
But at a point, Quayla, she just got quiet and was on her phone, and you could tell something was off, and she just was flying at like she was mad. She was mad, and then she was just ranting and venting and stuff. I didn't really know exactly what led up to us going over there. I just know she seen something on her phone, pissed her off. She was ready to fight at that.
Okay, so Ms. Powell's ready to fight Ms. Smith.
Yes.
Okay, are you planning on fighting anybody? I mean, what is your role here?
So there was a girl that Miss Smith had sent on me. Her name is.
Wait, let's back up. What's the sent on me?
She had her cousin text my phone trying to fight me because her cousin knew me and we went to school together. And that cousin was actually here in court yesterday. Her name's Pelagia. She was sitting in the back of court.
Okay, so it was your understanding that you may have to fight this
Yeah,
Miss Lee?
yes, it was my understanding that I was probably gonna have to fight Miss Lee that, yes.
Objection, Your Honor, again, to hearsay. Now we're talking about text messages with someone that's not even witness.
Your Honor, we're going to she's testifying as to what her understanding was and when she was heading to this fight. We're not using the truth of the matter of the statements, that we're going to her state of mind, essentially.
You're objecting to the text messages she received.
Yes, Your Honor.
And
as
she didn't
your-
tell us what the text messages said,
No, Your Honor.
but
but-
her understanding.
Yes, Your Honor, and her understanding is learned from hearsay information that we don't have any evidence of. We haven't heard of this until right now, so I'm objecting to this.
Well, it goes to her state of mind, so the objections are ruled.
Yes, Your Honor.
Okay, Ms. Otis, so did you take any preparations to fight this, Ms. Lee?
I did. I had, at the time, my hair was in long braids that went all the way down to probably like my upper thigh. And I decided to put my hair in a low
Okay, well-
ponytail.
Well, let's back up and talk about your hair for a minute,
Okay.
because how did you go about having hair that was that long? at that
Well,
time?
I was prepared to fight Miss Leak at that moment. So I did, put my hair in a ponytail and I did put the speed.
Okay, but I'm going to
mask on.
your specific hairstyle at that
Mhm,
time.
Yeah,
Was that naturally your hair that long, or did you?
no, it was,
okay.
it was weave, it was extensions, yes.
So you had like a weaver extensions in your hair,
Yes, yes.
and were you concerned that those are vulnerable to?
Pull it out, yes, yes.
So what steps did you take to
I
protect
put
it?
my hair in a low ponytail and I put a ski mask over my head. Yes, I did.
And what is the point of putting that mask on your head?
It's just so my hair can get pulled. Just, that was it. You can't pull my hair. I have to.
And then do the four of you get in a car at that time?
We do, yes, we
Okay.
do.
And what happens after that?
We ended up we did go to Rainwright and we did call her. Well, not we, Miss Powell did call her. And we were trying to get her to come to Rainwright to fight and she didn't do it. So then we kind of left the situation alone because we figured, all right, well, she's just doing what she usually does. She doesn't want to fight.
And are these just phone calls at this time, or is this more social media?
No,
stuff,
it
or-
was a live video and Quayle was also on the phone with her. Yes.
So you have both going at this time.
Yes, yes.
Is Quayla using her own phone or someone else's phone?
She was using someone else's phone. She was using her phone on live, somebody else's phone to talk to.
So somebody who's not as social media savvy, so she's holding her personal phone to do like a Facebook Live,
Mhm.
and then
She said a yes.
Yes, sorry.
and she's using another person's phone to call Miss Smith.
Yes.
Any highlights or anything you learned from that situation?
As far as like.
Did you, based on these conversations, what did you do next?
From there, we did go to, or no, we was already at Rainwright. She wasn't fighting. She didn't say that she was coming to fight. So we left the situation alone at that point. Then that's when Miss Smith decided to go on live, like, oh, I want to fight and I'm going to get my BITCHs and all this stuff
Okay,
like
so
that.
when you say going live, are you talking about Facebook Live again?
Yes, Facebook Live. And she had went on live saying that she wanted to fight. So we did end up figuring out where she was at.
How did you do that?
Lansing is small. We seen her when she was on live. She had her phone propped up. We knew what apartment complex she was at. So we knew where she was and we did go over there, yes.
When you arrived, was it your expectation that she was going to have multiple people there?
We knew that she did have one other person there, but the way she was talking on live, it was going to be more people calling over there as well.
Okay, so you were anticipating more people potentially showing up.
Yes.
So let's get to when you arrived there. What do you do? Or first of all, what is the first thing you guys do when you get there?
First thing that I do is I grab my phone, I started recording, I got out the car and
Did you turn that phone on like right as you're getting out of the car, or is there a bit of a delay?
no, this is right from the jump of everything, right when I got out the
Okay,
car.
why would you want to record this?
It was already on social media. Everything was already going on social media. Everyone videotapes stuff nowadays. So I guess if a fight was to happen, it probably was going to get posted on social media after, yes.
And, all right, so what happens after you start recording? Who goes where?
Quayla goes to the passenger side, which is where Miss Smith was sitting. Teresiah goes to the driver's side, and I'm by the car, but like behind the car at the same time. I'm next to it, but behind it, not really close to the windows. And I was recording. I was talking my mess as we all were. And
When you say talking your mess, what?
we wanted her to get out the car. My friend wanted to fight her. We wanted her to get out the car. Yes.
And were you planning to all attack her the second
No.
she got out of the car?
That was never in the plan.
What did you do moving forward after that after you started recording?
At that point, Miss Smith backed the car out. Our car, or Miss Powell's car, was blocked in. From there, it was really a lot of like back and forth.
Did you get back in the
arguing.
car? Or-
It was a lot of getting in the car, getting out the car, and we were trying to leave. Once we realized that she really didn't want to fight for real, we tried to leave, but she, backed the car out and blocked us in, so we couldn't. Every time we would try to like move to leave, Miss Smith would like back the car out or then back it in and back it out, back in, basically trying to block us in so we could not leave.
And do you get out of the vehicle at this time?
Yeah, honestly, I can't say specifically when all the times I got in and out of the vehicle because there was a lot of moving around in and out of the vehicle when everything was going.
Okay, well, what all is going on? What all do you see there? What is Naquela Powell?
Nyquela and Miss Smith, they had their physical altercation. They were, punching.
Well, where did that?
In the parking lot, like where the car was or whatever, where she backed in or backed out.
I guess were they inside the car, outside the car?
They were outside the car. Miss Smith was inside the car and Miss Powell was outside the car. And Miss Smith, she would like, I don't know, it was like 1 minute the window would be rolled down and she would be like going back and forth with Quayla, and then that's when like Quayla would go up to the car and try and like punch her and fight her, and then she would roll the window up and like roll Miss Powell up into the car, and then the door would open and then it wouldn't be open. It was a lot.
Did Miss Smith appear to be opening the door and closing the door?
Not from what I've seen. From what I've seen, it was Miss Powell opening and closing the door, but Miss Smith was rolling the window up and down, up and down, up and down, up and down, up and down.
At some point, you said kept people kind of getting in the car and out of the car. Were you leaving? Okay, so you arrived in a black Mazda.
Yes.
Were you staying around the black Mazda, or were you going over to Miss Smith's car?
No, I stayed by the black. I cannot say it. Mazda. That's where I stayed by. I never really went by Miss Smith's car besides in the beginning of when the altercation first happened.
Did you ever see anybody go inside of Miss Smith's car?
Like actually, like inside the car?
Yes.
No.
So you didn't see Kim Hinton go in the car?
No.
You didn't see Teresiah Edwards go in the car?
No.
Did you go in the car?
No.
Did you at some point strike at Miss Smith?
No.
Did you swing and miss at Miss Smith?
No.
How close did you ever get to this?
The closest I ever got to her was in the beginning when everything first went down and I came up to the car recording and got her reaction. That's the closest I ever got to her with the situation.
Okay, how does this, why would we hear from Miss Smith that you climbed in the back seat and started striking her from behind?
Well, Miss Smith has an issue with me because she has I guess you could say she has a sexual relationship with my brother. And she was mad that I showed up with the other party instead of being on her side, which the other party has been my friends for years. I did not know Miss Smith until all this stuff happened with the whole, baby daddy situation with my friend.
I guess how long has your brother been in this sort of dating relationship with?
I don't know that either because I didn't know that they had a, sexual or whatever they have going on. I didn't know this until after everything happened and my brother called me like tripping out on me about everything that happened.
Okay. How does the confrontation between the groups end here? Oh, hang on, let me back up one second. At some point, did you see Miss Smith's friend Haley?
Yes.
Okay, what does Haley do?
In the beginning, Haley was like it's like she was like in the middle, like by the grass area. It's like a parking lot and then like sidewalks. You gotta walk up there to get to the townhouses. She was like by the houses at first. She was getting her daughter, I believe. And then when she came back out with a bat, like swinging it. No, she never struck anybody, but she was, swinging as if she wanted to.
Did anybody? So Miss Haley never touched any of you?
No.
Did any of you touch Miss Haley?
No.
Did it appear that she was just there to make sure nobody essentially jumped Miss Smith? Is that?
I guess you can
You
say
don't
that.
know.
Well, Miss Smith was already with Haley, so
Okay.
yeah.
When do you get back into the car for good?
When we seen the police lights pulling, like turning the corner is when we all got into the car, and then that's when Miss Smith moved the car and finally let us out of the car.
How far away were you from the car when you first see the police?
Not far at all. I was standing in the door. like I was like in the car, but standing out of the car, if that makes sense. Like standing behind the driver, the back seat. Yeah, the back seat driver's door.
Okay, so the door open?
Yes, the doors were open.
And you're essentially standing behind that door,
Mhm.
behind that open door,
Yes.
right next to, essentially you could jump in, but you're standing there. What was the point of standing there?
I was just standing there watching, honestly, just watching everything that was going on.
Did your vehicle pull over as soon as the police asked them to?
Yes.
Did you comply with Officer Hurd's requests?
Yes.
And again, I guess one final question, like I said, at any point during this whole situation, when you arrived, all the back and forth, all the kind of the chirping going on, did you ever strike Ms. Smith at any time?
No, I did not.
Your Honor, no further questions at this time.
Thank you, Your Honor. Morning, Miss Otis. Thank you for being here again today. I know it's your trial and all, but you would be surprised how many times people don't show up to these things. So on your direct examination, you actually said something I think kind of summarizes this whole situation pretty well. You said that there was a lot of cattiness back and forth going on, right? To be clear, the cattiness that was between Nyquilla and Kiana
Yes, it was never between anyone else besides them.
never involved you.
Never involved me besides, Miss Powell, texting off of my phone. It never had anything to do.
We'll get to that in a moment. Just to be clear, you weren't the source of the drama.
No.
You could have just stayed out of it.
Yes.
It would have just been talk on social media potentially, or at least you wouldn't have been involved in anything physical if you did.
Yes.
You could have just ignored it.
Yes.
Everyone could.
Yes.
Nyquilla did. Right?
That's true, yes.
And you did. Right?
I mean, did I ignore it? I mean, there's nothing for me to really.
You went with Nyquilla, didn't you?
I did, yes.
So you didn't really.
We were already with each other, though.
Fair enough. You said at some point during this that Miss Smith actually stopped responding to Nyquilla entirely.
Mm-hmm.
You
said yes.
Yes, I'm sorry.
Okay. You said that's why Nyquilla then started to use your account to message Kiana?
So when the messaging had happened. This was already after she had made numerous posts about us.
Fair enough. I'm just trying to focus. I'm just trying to
this
focus on the
yeah.
messages that
Mhm.
day. Because you said that Miss Smith stopped responding to Nyquilla
Mhm.
and then Nyquilla used your account to message her. Is
Yes.
that right?
Mhm.
So it did come off your account. Fair.
Yes,
That account being associated with your name.
yes.
Fair to say we don't have some sort of a video or anything like that that can show it was Nyquilla sending these, right?
Yeah, there's no video.
So what we know is that messages from your account were
Mhm.
sent to Miss Smith
Mhm.
after she stopped responding to Nyquilla. Fair?
Yes, yes.
You said that this was all about the time the sun was starting to set. So
Yes.
we're talking late July in Michigan. That could be pretty late. Are we talking like 7 p.m., 8 p.m., 9 p.m.? That's when the sun generally starts to set in the sun.
I cannot give you an exact time because I honestly don't know, but I can definitely say it's late. It was late afternoon. It was around the time the sun was,
After
already. It was
After
already
6
dang near
maybe?
set. It was dang near already set. Honestly, it was already dark outside.
So maybe after 8?
Yeah, maybe.
Okay. You said that you were trying to get Miss Smith to come to Wainwright to fight you, right?
Well, I wasn't trying to get her to come to Wainwright. Miss Powell was trying to get her to come to Wainwright to fight her, not to fight me.
You were all together when Miss Powell was on Facebook Live and calling her, weren't you?
Yes. Mhm.
You were all at Wainwright.
Yes.
You were all telling her, or at least Miss Powell, on behalf of all of you, were telling her to come to Wainwright to fight.
It wasn't all of us though. Miss Powell was the only one on the phone with her and the only one on Facebook Live. We were just there.
And then you said on direct that she didn't, so you just ignored it.
Mm-hmm. And we left it alone.
You didn't really leave it alone, did you?
After she had went live again on Facebook and she was trying to, or after Miss Smith decided to go on live on Facebook, trying to make it seem like she did want to fight and that she was going to get people to, come over there so we can all fight and everything like that, we did continue to, go on about it. But once Miss Smith decided not to go to Wainwright, we left it alone until she went live and all that other stuff.
And then you didn't leave it.
That is true.
Now, you've been in court this whole time, right?
Yes.
You've seen all the testimony.
Mhm.
You've seen the videos.
Yes.
Now, and in fairness to everyone here, we have had some testimony that perhaps we don't have all the videos leading up to
That is
this,
true.
right?
Yes.
So in the video that we had from Kiana,
Mhm.
where in there, before you guys show up, does she start talking about bringing out people?
She never showed the full live. She never showed the full live. She was live for about an hour before we even found where she was at, because she did move around a lot on the live. She was at Morris first, because we did go to Morris when we seen where she was at. We seen she was at Morris. She ended up moving from Morris to the apartment complex, and that's when we went to the apartment complex. But
So let me just, you added some detail. Let me just try to clear this up.
Okay.
So you said that in fairness to us, like I said, we don't, it sounds like have all the videos from that day, right?
yes.
There were some more videos going on for about an hour before, is what you're
Yes.
saying.
It was, it was more of that. She only showed a portion of the live. She didn't show the beginning of the live and all the talking and everything that she did up to that. She only really showed the last 15-ish minutes of her live, and that was,
Miss Otis, to be fair, the videos that she showed were all of the ones where you guys actually showed up.
Yes.
You hadn't been in any of the other videos, right?
Mhm.
It was all just talk on social media. And what you're telling us now is that these videos were going on for an hour and she was at a different apartment, right?
No, she was at Morris River.
She was at Morris River.
Yes.
You saw that.
Yes.
Then all four of you went there
Yes.
after seeing it in the background and just figuring out where she was.
Yes.
Then she goes to a different apartment, right?
Yes.
You see that one in the background too, right?
Yes.
Lansing Small, that's what you
Mhm,
said.
yes.
You knew where she was.
Yes.
Then you followed her all the way there too.
Yes.
Your statement to police, you heard it during this trial, didn't you? The first witness?
My statement,
Right.
I don't remember hearing my statement.
You remember giving a statement to police, don't you?
Yes, I do.
You remember hearing Officer Kurtz testify, our very first
Yes,
witness?
yes, yes.
You remember him talking about what you told him? or no?
No.
Your statement to police, would you disagree that your statement to police was that you were invited over there for a mutual fight?
Oh, yes, I did. Yes, I did say that to the police.
So you were invited over there for a mutual fight?
Yes,
That was your statement to police?
yes.
Now you're telling us that you went to not one, but two separate locations to find her?
Well, we knew where she was, and as far as I'm concerned, when you're on social media, like wait until I call my friend and wait until I call my VITCHs and we're gonna do this and we're gonna do that. We had the impressions that she did want to fight, and it was multiple situations where she was putting on the perception that she wanted a fight. She wanted a fight. Miss Quayla, I mean, not Miss Quayla, Miss Powell was gonna fight her. I was gonna possibly fight her cousin, and that was that.
Ms. Otis, to be clear, all of these things about she wanted to fight somebody, those were all directed at NyQuil.
Yes,
You could have just stayed out of this,
that is true, yes,
but NyQuil is your friend,
yes.
so you don't want to leave her alone.
No, I did not.
You wanted to back her up.
I did.
So I guess my real question is here, how is it that you were invited for a mutual fight somewhere, but you had to go to not one, but two separate locations and follow this girl around Lansing that night to finally get your hands on?
I never put my hands on her. However, though, I will say that we should not have went, looking for her. Because she technically did not give us an invite, but we just felt like she wanted to fight because of everything that was going on prior, all the smack talk and everything.
And there was a lot, so I can't necessarily say I blame you for getting that impression. Nonetheless, what we have here is that you weren't actually invited to fight. You followed her to two separate places that night.
Yes,
Simply by watching her Facebook Live and tracking her location that way.
yes,
Now, you said that we knew she did have one person over there.
yes, we did.
That
She was
person
in the
being
live
Haley.
talking to, yes,
That person being Haley, right?
yes,
Not Miss Lee.
no,
So as far as you knew, the only person that was Haley,
yes,
not Miss Lee.
no,
Nonetheless, on direct, you said that you were making preparations to fight Miss Lee.
yes,
You were prepared to fight. That's what you said, right?
I was, yes,
That's what that mask that we saw you wearing was?
yes.
Fair enough. Miss Lee wasn't there, was
No,
she?
she was not.
Fair to say that when you're in this state, right? You're putting on this mask, you're getting ready to fight, you might be a little worked up. Is that fair?
I can say, yeah, yeah,
A little bit angry.
yeah,
You said that you were all talking your mess, right?
Yes, we were.
Everyone was.
yes,
You started to record this when you showed up.
I did.
Why'd you start recording?
I mean, everything gets recorded nowadays. You see people recording fights all the time and putting it on social media.
So
I
were you
mean,
planning to record this fight or jumping or whatever of
it-
Ms.
it
Smith
was
and
never
put
gonna
it on?
be- It was never gonna be jumping. It was me recording the fight of Miss Powell and Miss Smith.
So what you're planning to do is record a fight, hopefully Miss Powell wins, and then all of a sudden you get to post it and embarrass Miss Smith. Is that fair?
Yes, yes,
On your direct, you told us that Miss Smith backed out her car, right?
she did,
She blocked you in.
she did,
At that point, you guys got back in the car, right?
yes,
And I think we see all that on your video, fair?
yes,
Then at some point, cars are kind of eat her back and forth,
Yes, yeah.
right? Blocking you in. Now, you heard Miss Smith testify that that was because she was calling police and she wanted them to stop
that's not
you.
true.
Nonetheless, you heard her testify to
Yes.
that.
Mhm.
Nowhere in your direct examination testimony did you never mention her hitting someone with a car, did you?
I did not.
You heard Tara Saya yesterday, right?
Mhm.
Saying,
Yes.
accusing Miss Smith of hitting not one, but two people with a car.
But she did, and
Oh, okay.
yeah, she did. She hit me with the car, and she also hit Miss Powell with the car as well. She hit Miss Powell a lot worse than me. I'm not gonna sit here and act dramatic as if she ran me over and tried to kill me. But when she backed out in the video that I showed in court, when she backed out, she did hit.
Where on that video do we see her hitting you exactly?
I mean, you don't see it, but it was a little bump. Like I said, I'm not gonna sit here and act dramatic, like she just full force rammed into me, but I was hit by that vehicle.
Fair enough, and I guess while we're on this train about not acting dramatic or over dramatizing, You did see Haley with a bat, right?
I did.
But to be clear, Haley was like all the way at her apartment.
At first she was, eventually she did walk up to her car, yes.
So in fairness to Haley, or maybe you can tell us, essentially what she saw was a group of the 4 girls
Mhm.
outside of Kiana's car, and she came outside.
You're asking what, who saw?
Haley,
I thought she testified to what Haley said.
rephrase her. Could you see Haley?
I did, because he.
And what was going on when she came outside was 4 girls around her car, right?
Yes.
That had Miss Smith inside.
Well, hold on. It wasn't 4 girls around her car. It was Miss Powell around her car, and everybody else was just kind of around there, but no one was all hovering over her car trying to attack Miss Smith. That was never a thing.
Fair enough. Nonetheless, let me phrase it this way. When Haley came outside, there was 4 of you and 1 of Kiana.
Yes,
She then brought a bat with her.
yes,
She didn't hit anybody with that bat.
No,
She was just kind of swinging it at the air.
yes.
Not even really close to you.
No, not close to us at all.
Probably like 10,
Nowhere near close to us to be able to even strike us with that.
more than 10 feet maybe?
Yes, yes.
Okay, what about more than 20 feet? Super far or?
She
say more
wasn't
than
super
10.
far. She was far enough to where she couldn't hit us.
You can't tell us specifically when you got in and out of the car, can you?
No, because it was a lot of in and out of the car.
But you did get in and out of the car a lot.
Yes,
You did see Miss Powell opening and closing the door.
I did, yes,
So the door was able to be opened from the outside. Is that fair?
it was.
So really what we're here for is you hopped on a car with 4 of your friends, right?
I did.
Or 3 of your friends.
I did, yes,
You followed Kiana Smith to not just 1, but 2 separate locations, right?
yes,
Then when you got to that location, you got out and started recording a video that you planned to post on the internet later.
yes,
Fair to say you were the one recording that video?
I was,
Fair to say you're in control of when that video starts and stops?
I am.
Fair to say you could have stopped recording at any point,
That is true.
and then all of a sudden, we don't have a video that shows anything.
Okay.
After that video stopped, that's when you got out of the car, isn't it?
Yes,
After that video stopped and you got out of the car, you went up to Kiana's car,
no,
didn't you?
I did not.
You went into the back seat,
No, I did not.
you reached over,
No, I did not.
and you started assaulting her.
No, I did not.
You heard the 911 call, didn't you?
I did.
You hear all that muffled, get the
I
fuck
did,
out the
but
car,
that's,
get
but
the fuck
that's
out the
not,
car.
but also in the video, if you play it back, that's not my voice. That's Miss Powell's voice. Once again, it was never my fight. It was Miss Powell's fight.
Fair enough, but there's a lot of muffled noise going on there, right?
But you can also hear a little bit of the voices in the video, and it was never my voice.
Right, I'm not
Yeah.
disagreeing that
Yeah.
that was Miss Powell's voice
Mhm.
saying those things. That was gonna be my next question. She was the one telling her to get out the car.
Yes,
That's not the same thing that we saw in the first video of her pounding on the window, right? That's a different instance.
yes.
That's later.
As far as,
The 911 call, what we
yes,
heard.
that was later.
That's
that was
later. That's
yes.
after all the videos stopped.
Yes,
Your testimony today that muffled noise was not you
That was not
assaulting
me, no.
Kiana?
that was Miss Powell and Kiana going back and forth. They did have their little brawl or whatever you want to call it out the window. Kiana was throwing her punches as well. Miss Powell was throwing her punches, but it was never me throwing any punches at that girl. No, at Miss Smith. No.
Fair to say you could have just stayed out of this whole situation.
Yes,
You could have just not gotten in that car.
that is true. Yes.
Thank you. No further questions.
Redirect.
When you stated that you got bumped with the car, that you said that was right at the beginning while you were
Yeah,
recording?
that was right at the beginning.
Are you, is the camera, how high are you holding the camera?
I mean, I guess it's just like a normal. I don't know.
Are you holding it shoulder length, kind of high?
I mean,
or-
not high. I was just, I guess you could say like right here. I mean,
Okay, so kind of right in front of your chest.
Yeah, yeah.
So if you were to get bumped in the leg a little bit, that wouldn't show up in a video, would it?
No, it wouldn't. And like I said, it wasn't like a really powerful hit, but it was still a hit. I felt it.
Then we saw in the video previously how, you get back in the car. Why do you turn the recording off at that point?
There was nothing happening. We assumed that it wasn't going to be a fight. Once she backed the car out, we thought that she was going to back the car out and try and leave. but that's not what happened. She backed the car out and blocked us in. I stopped recording because we just simply thought nothing was gonna happen. It was the same stuff that been happening.
Were you expecting to leave yourself at that point when you stopped recording?
Like just me? Or
Well, the car,
yes, we were expected to leave. We were trying to leave, but
because at that point, all four of you were in the car when you stopped recording, right?
yes,
And we've seen previously on the video that your car, that Ms. Powell puts her car in drive and tries to pull out and leave at that time, right?
yes.
And one other question. Did you know Haley at all prior to this incident?
No.
Is this really the first time you've ever had contact with her?
Yes.
So
And realistically, there's never ever been really any contact between me and Haley, even before like this. I mean, after this event and during, it was never me talking to Miss Haley or Haley, whatever.
So you've never had any issues with
No, no.
Your Honor, I'm done with my questions. I think we're all
Any
set with
questions
Ms.
from the
Otis.
jury? Okay, I just have a couple. Okay, so your testimony was correct, I believe. That, who was the driver of the vehicle? I don't know if you testified to that. Were you driving?
No, I was not driving. It was
Okay.
Miss Powell that was driving.
Whose idea was it to drive to these two locations?
It was Miss Powell's. Yeah.
Ms. Powell's idea?
Yes.
Okay, so did you have control over that idea? Or did you influence that idea?
I
at all?
didn't influence it. I'm gonna be honest, I didn't try to stop it either, because she's a grown woman, that's her decisions, but I never influenced and was like, oh yeah, go, let's come on, let's go. No, that was never.
Okay, and then your testimony was that you never hit her, but did you swing at her?
No, I did not. I was
Okay.
never by the car.
Okay.
Besides in the beginning when everything first happened, that was the only time I was ever near that car.
Did you threaten her?
No, I did not.
And your testimony was that you were there prepared to fight someone else
Yes, I was there to fight someone else.
who
Yes.
wasn't there?
She ended up showing up once the police got there. Yes.
The person that you thought you were gonna have to fight?
She did end up showing up, but it was after we were already detained and everything.
But you weren't there for the purpose or to fight Kiana Smith?
No, I was not. It wasn't my fight. It wasn't my battle. It didn't have anything to do with me.
Where were you seated in the car?
I was seated in the back seat, and at first when we arrived there, I was in the middle. And then as we were getting in and out the car, me and Miss Hinton were kind of like switching back and forth. Whoever got in the car first was in the middle on the side.
Okay, and when you arrived, did you have the ski mask on?
I did, yes.
Did you ever take it off?
Once I was detained, I did take it off, yes.
Okay, but you, during this back and forth between you all, the group, did you ever take it off during that time?
No, I did not.
Okay. Got any redirect based on that? Or
No, Your Honor.
still no questions from the jury?
No.
Okay. You may be excused from the stand. Any additional witnesses?
No, Your Honor, the defense rests at this time.
Okay. You don't have to be calling rebuttal witnesses at all.
No, Your Honor, I won't be calling any rebuttal witnesses.
Okay, we'll go off the record for a few minutes. I need to over some final, or we need to prep some final instructions, and then we'll bring you back for final instructions in the closing arguments. All rise for the jury.
Can anyone hear me?
We can hear you, Mr. Wells.
Okay, so now what's going on?
We were waiting for the attorney that is on your matter to come back in the courtroom, so we proceeded with the jury trial. The judge will call your case when she's ready.
Is there anyone getting my messages stating that I'm at work on a break?
Matter. Where's the person here for cops?
She left back out.
She said she was going to the canyons.
Yeah.
Yeah.
I'll send David a message.
Small claims and representative here from Berkshire. Okay, and what's your name?
Debbie Brennan,
And what is your role for Berkshire?
managing broker.
And Michael Hernandez is present?
Yes.
Which one? Who's Michael Hernandez? Okay,
I'm his power of attorney. Yeah.
okay. Mr. Hernandez. So you're his power of attorney?
Yes, I have power of attorney.
In what capacity?
He's disabled,
Okay, in what capacity?
mental, learning disability.
Did you all meet privately to, at all? Okay, once I finish with jury instructions, so that they can deliberate, then I'll be able to start your matter.
Thank you.
Do you have any changes to the composites?
I do not, Your Honor.
And then, Mr. Marquardt, when you make a request, please put yours in numerical order. It's all the back and forth. It takes it longer for me to make sure I didn't miss anything you have. I think you went from 3 to 5 to 17. Just put it all in numerical order.
On which?
On your
the
request on your proposed.
Oh, okay, I'm sorry. All right,
No problem.
I was working off an old draft from Mr.
I
Martinez, so-
assume because I think you had didn't delete the old date out of there either of the internet. So I said he must have used someone
Oh,
else's
no,
draft.
okay, that's on me, I'm sorry. Yeah. I'll do it myself, stretch each time. I have no issues or objections with the proposed instructions, Your Honor.
Okay, anything before we bring the jury back?
Oh, Your Honor. No, yeah.
Okay, bring the jury. in. All right, let's do it. Okay, thank you. You can be seated. You can proceed.
Thank you, Your Honor. Do I have co-host permission, Bonzo?
How you doing?
Morning, members of the jury. Thank you again for being here for a second day now. I know we promised you a one-day trial, but welcome to court. Things don't usually go how we plan. So sorry about that, and we'll try to get you out of here as quick as possible. But of course, you've got a very important job in deliberating and deciding this case. Especially important considering I feel like, I'm not sure if anyone else feels this way, but we have been caught in the middle of an episode of The Real Housewives at this point. There is all kinds of drama going on here. There is all kinds of underlying beef. From the start of this trial, I have not tried to ignore that. I have not tried to shy away from it. But what I have tried to do is let you know that that underlying beef, all that drama, that's not what we're here for. We're here for a case of assault and battery with Kiana Smith as the victim, our defendant, Jada Smith as the accused. At the start of this trial, you were asked in voir dire, if there was no evidence and you had to go back to deliberate now, what would you do? Said not guilty, and it was the right answer. Now we have evidence. Now you have something to look at, and now it's going to be your job to decide whether or not the defendant did assault Kiana Smith. By assaulting, and the judge will give you these instructions again, but simply by assaulting, again, I have to prove that there was a forceful, violent, or offensive touching committed on Kiana Smith or something closely connected to her by this person, Jada. As I told you at the start, I don't have to prove she even landed a blow. I don't have to prove that there was an injury, although I know people might want to see things like that. What I also don't have to prove, and I want to make very clear, is I don't have to catch this crime on camera. And just because it's not on camera, because someone stopped recording to either call police or for whatever reason, perhaps to commit an assault, just because it's not on camera doesn't mean it didn't happen. You had a real life person come here before you and testify to exactly what happened to her. At the start of this trial, I posed a phrase to you, and I will repeat it again. If your friends jumped off a bridge, would you do it too? Because that's why we're here. We are here because Jada Otis's friends jumped off a bridge and she decided to go right in after them. Without looking, without taking any extra caution. And as we found out throughout the course of this trial, it's actually a little bit more egregious than I even once thought before this case. What happened here was there was an ongoing dispute. You heard this from everyone. It is undeniable at this point that both parties were going back and forth with each other. But remember back to the defendant's testimony today, because I think she actually outlined pretty good how this beef went. What happened first was some posts from Kiana ambiguously at her child's father's new girlfriend. Not directed at any person, but mad that her child's father was dating someone else. And no, I don't condone any of that behavior. And I could see how someone views her as someone that's instigating a fight in this instance. But to be clear, instigating a fight is a lot different than assaulting and battering someone. It's a lot different than fighting. It's a lot different than putting your hands on someone else, which we're all taught since kindergarten is rule number 1. Keep your hands to yourself. Members of the jury, what we have here is an ongoing dispute where Kiana started making some posts. Naquilla went back at it. Back and forth, and back and forth, and back and forth. It's social media, it's 2024, and at the end of the day, they're young kids. This all escalates into messages being sent from the defendant's account, but not from her, if you believe her story. Just from her account on the night of July 26th, 2024. Why? Even in her own words, why did these messages come from her account? Because Kiana Smith stopped responding to Naquilla. This could have all stopped right there. Jada didn't have to let Naquilla use her account. So if we want to talk about instigating a fight here, which I suspect will be brought up and will be argued, members of the jury, there's only one person who stoked those flames, on July 26th. It's the defendant. When she either sent those messages directly or let someone else use her account to send those messages after the victim stopped responding. And then what happened? Some phone calls, hours and hours of social media back and forth until the defendant and her friends decided to get in Nyquilla's car. Yes, Nyquilla was driving, but at any point she could have just not gotten in that car, asked her to pull over, or gotten out of that car. So I'd ask you to hold her accountable for the fact that she did get in that car. She willingly participated in this whole thing. And what happened was that on the night in question, and excuse me a moment. Give me a moment, Ron. Some water, maybe?
Yeah. No problem, take your time.
May I proceed, Your Honor? So what happened was, on this night, these girls saw some posts. They got mad. They found out where Kiana was by watching her posts, and in her own words, Lansing's a small town. They knew where she was and they could find her. So what'd they do? Well, of course, they got invited to a mutual fight by driving to not just one location trying to find Kiana, but then driving to a second location with 4 people in a car, armed with brass knuckles and other weapons. It's not an invite to a mutual fight by my definition. By I think any reasonable person's definition, a mutual fight is 1-on-1, not 4-on-1, not weapons, not any of this other stuff that was going on. An invite to a mutual fight, this was not. You heard her testimony today. The person she was apparently going to there to fight with, after she got all dressed up, ready to fight, as she described it herself, that person wasn't even there. So let's take the defendant's story for what it's worth. Let's take it at her word. Let's assume for the moment it is all entirely 100% true. That's all the facts you have, right? Let's imagine you get all geared up. You put your mask on. You're ready to fight. You're all amped up. You're ready to go. Then you show up and the person you're supposed to fight, they're not there. Are we really supposed to believe she just stopped? She just cooled down. This all just ended as soon as she saw that person wasn't there. Or is it more reasonable that in this state she was in, all amped up, ready to fight, she made a mistake, got out of the car after she cut off her video and she assaulted Kiana Smith because she saw her friend already inside the car? That's a question you'll have to answer when you go back to deliberate. Another question that you're going to have to answer, because I'm not going to tell you how to decide this case. It's your job, members of the jury. I don't pose these things to you as questions because I'm not confident. I don't have an opinion. I don't want to bias you with my opinion. What else you're going to have to decide back there is who's more credible in this whole situation. You'll be instructed, and I won't read the whole thing verbatim, but you'll have an instruction back there about assessing witness credibility. You have to assess things like, did the witness have a good memory? Does the witness's age or maturity affect how their judgment might affect their testimony? Does the witness have any bias or prejudice or personal interest in the case? Has there been any promises, threats, suggestions, or things like that? I think all things that we all use are normal common sense to generally figure out. And think about the witnesses that were presented to you. Yes, I presented 2 officer witnesses. Frankly, based on all the witnesses that were presented, they might have been the most removed from this situation and the most independent of it all. Bias, prejudice, things like that. I'm not sure we have it with the 2 law enforcement officers you heard from. And what did they describe? They told you that they arrived in response to a weapons complaint that turned into an assault and battery. Officer Kurtz told you he stopped a black Mazda that had, or assisted in stopping a black Mazda that had 4 people in the car, the defendant being one of them. He took her statement, and her statement to police was all about this beat and that she was invited to a mutual fight. What did Officer Bakri tell you? Officer Bakri told you that when he arrived, the first responder, the very first officer on scene, what he saw was a car, Kiana's car, blocking a black Mazda in, or at least appeared to. Kiana told you herself, the reason she blocked him in was because she wanted police to respond and for police to handle this situation, and for these people to not get away with what they were doing to her. Was that a smart move? I'm not sure. Was that a great move? Not really. But members of the jury, she told you herself, the only reason she blocked them in and stayed inside of her car, not blocked them in and then got out to fight, is because she wanted police to arrive. And then when police got there, Officer Bakri was within eyesight. What did he tell you happened? That black Mazda went right around that car and left. So this whole thing about Kiana blocking him in or not, and the cars going back and forth, well, all of a sudden, as soon as officers arrived, that car was able to get out of there just like that. And importantly, what did Officer Bakri tell you about what happened right before that car fled? We remind you, he stated that the rear passenger door, potentially the one that the defendant on video, her own video, gets in and out of, the rear passenger door opened, someone peeked their head out, then it closed real quick and that car was gone. Then you heard from Kiana Smith herself. Won't rehash all of her testimony. You'll have the video accessible to you if you want to watch it again. I will summarize it, and I do not condone a single word of what she was saying on those Facebook Live videos. I don't condone her actions of talking smack on social media for as much as she was and for as long as she was. I don't think anyone does. I think we all know, and she said herself, it wasn't a good idea and she wished she would have handled herself better. What is not a crime is using your words on social media, no matter how bad those words are, unless they're threatening and harassing someone. And even then, members of the jury, there's exceptions to the law that we won't get into because we're not in a constitutional law class. But what's important to note here is that talking smack on social media is not a crime. What is when you respond to that with 4 people in your car, pull up behind this girl like we saw in the video, and you saw her face as soon as they started knocking on the window. You saw her face. Did that look like someone who was really going to back up all that talk? Did that look like someone who was really trying to fight? Or did that look more like someone who, as we have heard testimony of, stopped responding, didn't go to Wainwright no matter how many times she was told to, or else this would happen, didn't engage physically with these girls? That's who you saw in that video. The second her face froze when these people actually showed up. You heard all kinds of testimony about what happened right after that, and depending on who you believe or not, apparently Kiana hit some people in a car now too. Not going to get into all that, but members of the jury, there's some genuine credibility concerns, and there were some arguments made from the defendant about some sort of overacting, some sort of dramatizing. Well, it seems like to me everybody was doing a little bit of that. So I think that's a wash. Not only that, but from the defense witnesses, who did you hear from? The 3 people that were in the car. The 3 people that all showed up. Didn't hear from Nyquilla Powell, but heard from those 3 people that were all in the car. What is their potential bias? What is their potential personal interest? What is their potential motive in testifying in this case? Again, credibility. Not only that, but I elicited on cross-examination with all of them. They have been together. They're together all the time. They have been together a lot since the date of July 26th, a couple months ago. They have talked about this case, and then they came in here and gave an almost identical story. Members of the jury, I think this case can be summed up as nobody should have been talking smack. But the reason we end up in this courtroom is because those girls drove up. I want to play for you again before I get done here. Video and a 911 call. Like I said, you'll have my victim's video. I'm not trying to hide from it. You can watch it as many times as you want. I will show you the defendant's own video again, so you can see her own actions while this is all happening. And frankly, because I think it's a better view of what's going on outside that car. We'll play that 911 call for you. I'll let the defense make their argument. I'll get one more chance to speak to you again before you go back to the website. What I ask is that while you're watching this evidence and while you're deliberating, any biases you may have about what you think Kiana could or could not have done better, or what you may or may not have done in this situation, try to leave those at the door. Try to look at the evidence as it is. Keep common sense in mind, as you will be instructed you are allowed to do. Ultimately, members of the jury, you don't want to condone this sort of act. Getting into your car with your friends, going to two separate locations to find somebody and get in a fight. The 911 call, as I told you from the start, and I'll play for you again here, I think you can hear this assault happening in real time on that 911 call. I'll let you make that decision for yourself, because you're all reasonable, competent people who've seen the evidence. Your Honor, permission to publish People's Exhibit number 1 to the jury first?
Yes.
Get the fuck out the car. Get the fuck out the car. Get the fuck out the car, bitch. You want life? Get the fuck out that car. Get out that car, bitch. Yeah. Come on. Come on. We want you, dog. Come on. Get out the car, Bookie. Come on. Come on. Come on. Come on. Come on. Come on. Get out the car, bitch. Get out the car. This scary ass bitch. Hit it. Hit it, bitch. Let's go. Hit it, bitch. Get in the car. Get in the car. Get in the car. Come on, bitch. Come get out the car. Get out the car. Bitch, you're scary as fuck. Oh, let me reverse this bitch. Where's that? Right there. Get ready. Oh, she's trying to crash into it. Bitch, you better not hit my motherfucking car.
Hit it, please
Bitch,
hit
you
it.
better not hit my motherfucking car.
Get out, Kim.
Ain't nobody gonna jump you.
No one jumping you, Bookie. Ain't nobody jumping you. Come on. Come on. Ain't nobody jumping you, bitch. Get the fuck out the car. Get the fuck out the car.
Ain't nobody gonna jump you, Bookie. Come on. Ain't nobody
Ain't nobody finna jump your weak ass bitch. You're nobody to jump. You're nobody to jump, bitch. Get the fuck out the car.
Oh my God. You want me to stay in the car? Nobody gotta jump you.
What's something I can throw at that shit?
Ain't nobody car. Don't ain't nobody car. I want that shit mine.
Okay.
Hold on, I'm about to move though. Hold that door. Hold that door.
They just thought shit was sweet.
Members of the jury, what the defendant would have you believe is that that video in somehow and in some way helps her case because you can't see an assault on it. But think, a person in that state saying those kinds of things, geared up with her ski mask on, ready to fight. And then right at the end, what does she say? Let me find something to throw at that car. So she's already talking about throwing things at the car. She's already in this state. She's all worked up. We've already had testimony that the door, in fact, from the defendant herself, did get opened and closed from the outside, despite this mysterious door argument made earlier. The door was open. People were able to get in, and they want you to believe that the defendant just stopped after that video. Just sat in her car and waited patiently for police to arrive. Your Honor, permission to publish People's Exhibit number 3 to the jury.
Commissioner granted.
For the record, I'll be starting at the 1:45 mark. The reason I'm starting here, members of the jury, is because this is where I think you can hear the assault happen in real time in a 911 call that we have undisputed testimony was made after all these videos.
Okay, do you know their names? You're so pretty. That's so Tiana. Tiana.
She just hit me in my face.
Okay, are you able to get inside the vehicle and shut the door so that they can't? You're not? Tiana.
You need to hurry up. I cannot talk to you guys right now.
We have police on the way, but do you know their names?
Right there, members of the jury. I think you can all hear it happening in real time, right there. An assault by not just one, but two people. This wasn't just a mutual fight. Kiana told you herself, she vividly remembers two different shades of skin punching her. One being a lighter complexion person that she saw was Jada Otis. The other being a darker complexion person that she saw was Nicola Powell. We have victim testimony. We have a 911 call, and no, I don't have the actual assault on video, but that's not my burden. So all I ask is that you hold me to my burden, you follow the law as it's instructed to, you assess the evidence, and you render a just and fair decision in this case. Because what we can do is put an end to this whole beef right here, right now. Thank you.
Well, ladies and gentlemen of the jury, I just wanted to thank everyone for paying such close attention. We've had a lot of witnesses in this case and a lot of evidence to listen to. And at the beginning, like I said, we both were asking you to keep an open mind, because sometimes you hear one witness and you watch a trial and you can get develop an opinion. However, you need to hear from all of the witnesses and put all of the evidence together before reaching a verdict in a case. And just going right back to what we just heard right there, addressing that right away. Well, Mr. Markarian is claiming, oh, look, that's when the assault happens. You listen carefully. While that is going on, you can hear, get out of the car, get out of the car. If a person was in the car fighting with the person, why would they be yelling at the woman to get out of the car? You can hear still knocking at the window. It's again, because this is when we hear the window going up and down and this being thrown through the window between Miss Smith and Miss Powell. And if you listen carefully, you'll hear Miss Smith state, she struck me in the face. Notice she doesn't say they struck me in the face. She said she struck me in the face, because it was one person. It was Nicola Powell. Obviously the first witness we heard in this case was Officer Jeff Cruz. He was not the first person on scene as an officer. However, when he arrived, they asked him to stop the black Mazda that was right nearby that was trying to get away from the situation. He testified that the car pulled over right away, that Miss Otis complied with all of his commands. From what he saw, the other people in the car complied with all the other officers that were involved at this time. He had no issues. That basically was his understanding that Miss Powell and others were, showed up when Miss Smith had challenged them to some type of fight over Facebook Live. That's what we heard from Officer Kurtz. Obviously, he was not there when any of the back and forth happened. He did not witness any of that. Then we heard from Officer Jamil Bakri. He testified that he was the first officer on the scene. And as he's approaching he does see the black Mazda finally able to get away from Miss Smith's car. Once Miss Smith her car finally kind of pulls back in, as we heard from other witnesses later on. Then that car was able to pull up. However, when the officers asked them to stop, they were happy to stop. They were trying to get away from the situation. Officer Bakri learned about this Facebook Live posting from Miss Smith. He testified that she was very reluctant to let him, see the videos or to have the videos. He eventually was able to get her to show her, about 5 minutes of video. And even then, she never turned over the video. We don't have the video from her. All we have is Officer Bakri's body cam video of the video, because that's all she would allow the police to have. When I asked Ms. Smith about this, she basically called Officer Bakri a liar, stating that she was reluctant, that she was more than willing to let him have all of it, even though she never did. She never turned over a thing to him. Never turned over a thing. This is a situation that happened 2.5 months ago, something along those lines. To this day, she's never turned over any of those videos to the police, even though she claims, oh yeah, I was happy to show him everything you want, give him everything you want. Officer Backy's testimony made it clear that was that was completely untrue. He also, described that what he watched in the video is something very different from what Ms. Smith was telling him was on the video. He made it clear that, yes, it came across as kind of a taunting, mocking type of comments being directed toward what we've learned to be Naquela Powell and Smith. After that, we had the chance to hear from Ms. Smith herself. And I believe when you look at the totality of the evidence, her testimony, I think, stood out for being just being completely different from everyone else's testimony and not fitting into all the evidence in the case. It was the outlier testimony that we heard. First of all, she testified, well, I just like to troll people online. That's nothing. That's something new people do now. Apparently unaware that's been going on for decades. I believe it was Judge Simmons herself even asked her that if she understood that, trolling was defined as basically harassing people. And she seemed surprised by that, as if that wasn't exactly what her goal was every step of the way with every post. Trying to basically laugh at and mock other people. And then like I said, she got up here and put on the victim act. That, oh, she's threatening me. I wasn't doing anything. This woman just started threatening me. But yet she would even still admit, yeah, I responded every single time. We later heard from other witnesses that it was really her that was initiating this back and forth, because she got social media juice out of it basically by laughing at and mocking Naquela Powell. So that's why she continued this process going on and on. And until we eventually got here. Again, she stated that, no, I didn't, these were, I would never threaten them. And she just laughed it off. However, we heard from Officer Backery, Kim Hinton, Teresia Edwards, and Miss Otis regarding her continuing harassment of Miss Powell. And that being related to the fact that Miss Powell is now dating her children's father, which is a frequent source of friction that I think many people can relate to, but through people they know and such. To me, the most important part of this case that completely blows apart this testimony is the 911 recording that we just heard parts of. Mr. Mercari didn't play the entire thing for you, and I think that was probably a good decision considering it starts off with her just blatantly lying to the 911 operator. And well, the prosecution loves to point out that posting nasty things on social media is not a crime. That's true. You know what? Lying to a 911 operator is a crime. And that's exactly how that begins. With her making up the story about women having guns. And, oh, yes, I've seen a gun. I'm going to die. And she's crying, she's putting on this act. It's completely fake. And you can tell that by the fact that right after she's afraid she's going to die, she's laughing and joking, mocking Naquela Powell, saying, oh, you're so pretty. And she's back talking to the yeah, I'm just telling her how pretty she is to try to get her to go away here. The whole thing was a big joke. And I think it was made worse by the fact that she was intoxicated and brought out some of the worst of Miss Smith. And then how does the 911 call progress from there? Well, basically, the 911 operator is still trying to talk to her to find out information that she can pass along to officers. And Miss Smith just basically starts ignoring her at some point so that she can, yell back and forth with Miss Powell. You can hear them in the background just jawing back and forth. The 911 operators, hello, or can you hear me? Can you tell me what's going on? And then the 911 operator has to, calls back because, as a professional, they're concerned. They want to get the information. But again, this is nothing but a big joke to Miss Smith, because she makes clear over and over. He claims that this contact only came through Miss Powell apparently being able to open doors, and we heard that apparently there were times that the doors did open and close. However, we also heard from 3 witnesses that she herself was rolling down the window so that she could throw out her latest salvo in the back and forth with Miss Powell. That as Miss Powell would get close, okay, you want to fight? She'd roll her window up. Again, is a joke in a way to mock Miss Powell. I think it becomes very clear throughout this whole event. And she's, she was recording at least through, I think probably 5 minutes into this incident, and had been on Facebook Live for, it sounds like, up to an hour beforehand with the same type of thing. And I think when you look at this too, this whole timeline of events doesn't make any sense. And she testified, oh, that could be partly due to her intoxication at the time. But if you recall, she repeatedly testified that she blocked that vehicle from leaving because she had called the police and the police were on their way. The trouble with that story is we have video. When they arrive when Miss Otis and her friends arrive on scene, she starts recording immediately. You can see them getting out of the car and approaching that car. I'd love to see you watch the video again. You'll notice that within 40 seconds, all 4 of them are back in the car to leave. Nobody's touched anybody. All 4 are in the car to leave. Instead, we have Miss Smith backing her car out first. And if you do the time, that the 911 call is nearly 5 minutes in length. So it is not possible for her to have made a 5-minute phone call in those 40 seconds prior to them getting it back into the car, unless she has some type of time turner or something that she wants us to believe. So it's clear to me that she backs the car out, traps them in the parking lot, and then continues to try to antagonize Niquela Powell to get her to do something dumb to get her in trouble with the police. That is Miss Smith's whole goal here. That is the way she's going to get one up on Miss Powell. And eventually there's some back and forth, and lo and behold, Miss Powell gets arrested. And that was her goal all along. Once the police arrive on scene, then she's fine pulling her car back in the thing and letting them go, oh, look, I'm innocent, I'm innocent. However, we've heard from all the witnesses and we've seen on video, her actions speak very differently. Then we finally got to hear from some of the other people there. And well, yes, was Kimberly Hinton a friend of Miss Otis? Absolutely she is. However, we also heard testimony that Miss friend Haley was there too. We didn't hear from her. I guess I'll let you draw your own conclusions as to why she may not have testified in this matter. Ms. Hinton, when she took the stand, like I said, she didn't deny the fact that she's friends with all these other young women. And she was the one who finally began to provide the rest of the story regarding this online harassment from Miss Smith, and Miss Smith essentially continuing to escalate the situation. She also testified that she and Jada Otis were in the back seat of the car. They got out, they were kind of hanging toward the back. You can see on the video, her testimony is backed up by the video 100%. You see Niquela Powell up at the main window, and then you see Teresiah Edwards kind of go up to the other window with her camera for a little bit. Miss Hinton and Miss Otis are kind of hanging into the back. You see Miss Otis is obviously the one with the, filming a little bit, trying to get a little film angle in there, and then backs away. Miss Hinton testified that through the rest of the event, there was, yes, they're getting kind of in and out of the car, but while Miss Powell was going over to Miss Smith's car, the other 3 of them were just hanging back at the black Mazda, and with the door open, kind of in and out of the vehicle, so they could chirp a little bit over there and get back in the vehicle to leave. And unfortunately, they couldn't leave. So, like I said, if you're concerned about, well, maybe Miss Hinton was biased, put on video, put on the exhibit 1. Just watch the video and see if that's what matches up with Ms. Hinton's testimony. I believe you'll find that matches up perfectly with what Ms. Hinton was testifying to. We also Oh, Ms. Hinton was also the one who first testified that, that you kept seeing the window get rolled down and then rolled back up by Ms. Smith. Ms. Smith would deny that. She claims that's, oh, no, it was just opening the door. But again, watch the video, I believe it's the exhibit 2. And you get a real flavor for Ms. Smith's actual behavior, the actual way she behaves, not the face she puts on for the courtroom or the face she puts on for her mom when she's here. You get to see the real person and aspect. If you think that's the kind of person who'd be rolling down a window, and egging somebody on and then trying to roll it back up, because I think that fits her personality perfectly. We also heard from Miss Edwards. Again, she is a longtime friend of Miss Otis. Nobody denies that. However, I think one of the things that really gives credence to a lot of her testimony is she was willing to testify to a lot of uncomfortable truths. She testified that, yeah, I saw my sister, going through the window and hitting at her, and I saw Miss Smith kind of hitting back at my sister. But she was very clear. Miss Otis never went up to the car. Miss Otis never touched her. She never got within an arm's length of Miss Smith. Miss Edwards testified that she was more willing than the others to certainly get into a fight if she got there. She testified that, yeah, I asked this Haley if she wanted to fight. She said no, so she didn't. Showing up somewhere and being willing to fight is not a crime. You actually have to have the contact, and that's where I think sometimes there's trying to get blurred here. In that, should they have shown up? No. I mean, I would advise anyone, don't show up in that situation, because bad things can happen. However, not standing by your car, filming a camera, that is not a crime. Okay, it's putting yourself in position for bad things to happen, and sometimes people start making allegations and you end up here. However, like I said, when we heard from Miss Edwards, she was very clear over and over that Miss Otis was never, after the initial filming, Miss Otis was never near Miss Smith's car and never touched Miss Smith. Today we got to hear from Miss Otis herself. I think she was able to give a lot of good background information on the disagreement and kind of the build up to this situation. Miss Otis admitted that, look, I thought I was going to have to fight this cousin, so I put on a mask because she didn't want to get her hair yanked out, because she had her hair, her hairstyle had a weave and extensions at that time, which I know I've never had those myself, but it's my understanding they were very easy to get yanked out and stuff like that, and she was protected. So she puts that on and keeps it on. However, again, you see in her film, she goes up filming, she gets back in the car, and then she's one of these people hanging back in the car chirping while Miss Powell and Miss Smith go at it back and forth verbally and then eventually physically. We also heard she cooperated with the police every step of the way in this situation. They said she did testify that, yeah, the car, when Miss Powell, I'm saying not Miss Powell, Miss Smith started backing the car up, just kind of had a little glancing blow in her leg. She felt it, but it wasn't any big deal. She is not somebody who's here trying to exaggerate in the same ways that Miss Smith was. I thought her testimony came across as very truthful. She admitted to things that could paint her in a negative light, because that's what the truth was. When it comes to, yeah, I was showing up to fight somebody. She was here to tell the truth and give the whole truth. And we appreciate the jury paying close attention and listening to them. In summary, look, if my friend told me that they're going somewhere because they want to fight somebody, I would do everything in my power to talk them out of it. Because in my line of work, I see a lot of terrible things that can happen in that situation. Fortunately, in this situation, nothing terrible happens. We have a little bit of an exchange between Ms. Powell and Ms. Smith, but nobody seemed to have at least gotten seriously hurt. And I'm not asking you to find that Ms. Otis acted appropriately in that situation by being willing to go along. All I'm asking you to is answer the question: did she ever assault or batter Ms. Smith? That is the question before you. If you recall, Judge Simmons actually asked the question of Ms. Smith, And Ms. Smith admitted to her that, yeah, I did say, wait till my bitches get here in one of my Facebook Live. That goes to the state of mind of the people who watched the video. Who did that include? Well, Miss Otis and her friends. They did not know she would be alone. They knew there was at least one person. There was a Haley. Haley didn't turn out to be a violent person, so it wasn't an issue. Some of the people, the one person she was concerned with arrived on scene after the police did, so after everything was over. So there's not an unreasonable conclusion that, you know, maybe we need to show up in this situation. Obviously, it would have been better if they found a more peaceful solution without having this whole situation go on. Back in opening statements, like I said, we both asked you to look at all the evidence to determine who was telling the truth. You know, we stipulated to admission of both of those videos. We stipulated to the admission of the 911 call for a reason. I think those make it very clear what side is telling the truth in this matter. We have not only the more witnesses, but we also have all of the evidence, all the videos. None of them show Miss Otis doing anything that she's accused of doing. The 911 call is just, like I said, a litany of lies by Miss Smith. So, you know, and if, you know, normally I would use the phrase, well, if you're willing to lie about small things, maybe you're willing to lie about big things. But honestly, lying about people being around with guns is a pretty big thing too. She just had no restrictions on her lying. As I was preparing for this trial, one of the questions that, you know, as a lawyer, a defense attorney, you want to be able to ask yourself, well, why would she lie about Miss Otis? Okay, because I understand, like, when it comes to Miss Powell, I would understand the embellishing that went on with Miss Smith in that situation. You know, there's always an uncomfortable situation. She's, you know, like I said, Miss Powell is dating her children's father. There's a lot of back and forth between the two. So, you know, I understand her kind of embellishing what happened because she wanted to get Miss Powell in trouble. Initially, during the opening, I told you that I thought it was, you know, most likely that, you know, she wanted to hurt Miss Powell by hurting Miss Powell's friend, Miss Otis. But as I watched the trial, I learned something myself, getting to see her testify for the first time. I think, and it goes back to when they're about to show the video in the courtroom, and she starts tearing up, oh, I don't want my mom to see this. I don't want my mom to see this. What we have here is a situation where an intoxicated Miss Smith embellished the story that night, you know, with that fueled by alcohol and anger at these women. She added things that didn't happen, like the gun, like Miss Otis getting involved. And then after the fact, she didn't want to have to admit to her mother and her family that she lied to the police. So she has stuck with the lie to the bitter end, despite how many other parts of this case she's been found to clearly have lied about. She's hung with the lie to the end because she doesn't want to let her family down. You can see that her family supports her very much. They were here throughout yesterday, supporting her. And she testified that, look, I don't even say a swear word in front of my mom. I would never, or my family, I would never do that. But we got to see the other face of this woman yesterday when we actually watched the video, the one that she doesn't want her family to know about. So the one last point I just want to bring up just one last time. Showing up is not an assault. You actually have to have some conduct of throwing a punch, swinging something at a person, striking them. There actually has to be a real affirmative act like that. Showing up and talking trash is not a crime. And that is all that the evidence showed that Miss Otis did on this occasion. So Mr. Markarian is correct that, you know, a lot of trials and stuff come down to credibility. And I think, to me, it was very clear that Miss Otis came across as far more credible than Miss Smith in this matter. But even if you don't find either of them credible, even if you're not sure who to believe, you still need to find the defendant not guilty in this matter. It's only if you believe beyond a reasonable doubt that what Miss Smith told you was the truth, that you can find her guilty. So, ladies and gentlemen of the jury, to me, at least, it is clear as day that the prosecutor in this matter has failed to meet his burden to show beyond a reasonable doubt that Miss Otis, you know, ever assaulted or battered Kenyana Smith on July 26th of this year or any other day. So therefore, we are asking you to return a verdict of not guilty in this matter. Thank you very much.
Yes, Your Honor. Thank you. Members of the jury, as you will be instructed at the end of this case, what we say as attorneys, it's not evidence. Evidence is the testimony you heard, the evidence you saw, the videos, the 911 call, and then your ability to decide and decipher and determine for yourselves what happened here today. Mr. Goodrich has a job to do and a client to represent, and I have a lot of respect for him. However, I don't. I represent the people. I'm not going to put someone who I think is knowingly lying on the stand, nor would I take a case to a trial that does that. Not only that, the 911 call is right here. It was sitting right on my table. He knows that. He could have played the whole thing for you if he wanted during his closing argument. I'm not trying to hide anything from you. It's all right here. You can watch it as many times as you want, members of the jury, but I think we've had a little bit enough of the Real Housewives in here. So that's why I didn't do it again and waste more of your time. Members of the jury, frankly, a lot of the defendant's arguments here during their closing are a lot like saying she had it coming to her because of what she was wearing. That's not how this works. You can't victim blame. It's not Kiana's fault that these girls decided to get in their car and follow her to not one, but two separate locations. It's not her fault that they somehow tracked her throughout the night across Lansing to two different areas, found out where she lived, and committed an assault. It's not her fault. She didn't bring this upon herself, aside from the fact that I don't blame Mr. Goodrich for arguing that she stoked the flames here. There was definitely some talk, but in his client's own words, again, what did you hear today? On the day of July 26th, she stopped responding. And the reason that this assault happened is because apparently someone else used the defendant's account with her name and started messaging this person that this ongoing beef was about, that the defendant is now accused of assaulting, and that the evidence, I believe, has proven beyond a reasonable doubt she did. Members of the jury, we want to get into a credibility discussion about who's the outlier testimony here. Well, if you have three witnesses who take the stand, who have had a lot of time spent together to coordinate their stories and talk about what they're going to say at court, all of a sudden, someone else might look a lot like an outlier. Haley has nothing to do with this case. Nyquilla, frankly, has nothing to do with this case. And that's what you heard a lot about from the defense. Nyquilla this, Nyquilla that, Haley this, Haley that. Every single time I tried to bring you back to the reason why we're here today. Because of Jada Otis and because of what she did. You have the evidence. You've heard enough from lawyers and suits, I think, quite frankly. But what I want to point out is that not once did Ms. Smith come in here and try to hide the truth. She wasn't trying to lie to you. She admitted to what she said in that 911 call and that she didn't actually see a gun. But what did she say? Someone from the defendant's car did say, put the gun back. All of a sudden, there's no gun. Members of the jury, you got four people that pull up on you in a car late at night. You hear someone talk about putting a gun back in the car. You see some brass knuckles, and then, of course, you're a little more excited. You're a little more exaggerated. And as she told you herself, she said those things knowing they were untrue, corrected herself as soon as the officers got there, simply because she was in fear and wanted police to respond faster. I ask you who might have done the same thing in this jury, members of the jury, who were faced with that scene that was outside of the car. The lie, the lie, the lie, the litany of lies. Okay, well, let's talk about the defendant's testimony. She put on a ski mask because she was getting ready to fight, but it was someone else, someone who wasn't even there, someone who had apparently texted her, sent her all these messages, and that's why she was really there. She was just there to go fight someone else that wasn't even there. Then Haley and her baseball bat, Haley and her bat, but don't worry, she wasn't even close enough to possibly hit anyone. Then this whole thing about hitting someone with a car, oh, it's just a little bump. Where did you even see the car get bumped in that video? Where did you see her get bumped? None of that adds up. And she brought her two best friends who were in that car with her that night to testify in support of her. That's why it's so easy to paint Ms. Smith as the outlier. Because just like that night, it's 4-on-1. That's why we're here. That's why an assault happened, and you can hear that arrest.
Okay, ladies and gentlemen of the jury, if you can put your attention on the screen, we have some closing instructions, and then I'll release you to do your most important duty, which is to deliberate in this matter. Okay, members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law as it applies in this case. Remember that you have taken an oath to return a true and just verdict only on the evidence and my instruction on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way, decide this case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that was properly admitted in the case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence include only the sworn testimony of witnesses and the exhibits admitted into evidence and anything else I have told you to consider as evidence. Many things are not evidence and you must be careful not to consider them as such. The fact that the defendant is charged with the crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my question to the witnesses are not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, ruling, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express my personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of the facts and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge when weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witness you believe or witnesses you believe and how important you believe their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on July 26, 2024, within the city of Lansing, Ingham County. When you go to the jury room, you may take a written copy of the jury instructions along with you and your notes. You must first choose a foreperson. The foreperson should see to it that your discussions are carried out in a business-like manner and that everyone has a fair chance to be heard. During deliberations, please turn off your cell phones and other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. As you discuss the case, you should think about all my instructions together as the law you are to follow. It is your duty as jurors to talk to each other and to make every reasonable effort to reach the agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because the other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my court officer. It is not proper for you to talk directly with the judges, the lawyers, the court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside of the jury room. When you go to the jury room to deliberate, you may take your notes, and again, you'll get a full copy of the instructions. If you want to look at any of the reference documents, which we don't, but we do have exhibits. If you want to look at any of those exhibits that have been admitted, you would ask. That we don't have a television in the jury room, so you would have to come back in here, and we will happily show you any of the evidence that was shown on the screen. When you go to the jury room, you will be given a written copy of the instructions that you have just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. You may return a verdict of guilty of the alleged crime or not guilty. I have prepared a verdict form listing the possible verdicts. My understanding is that was approved by both parties, correct?
Yes, Your Honor. Yes, Judge.
The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the statement or the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, taking the same example, if you see a person come in from outside wearing a raincoat covered in small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. So in other words, you should consider all evidence that you believe. When the lawyers agree on statements of facts, these are stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. There were no stipulated facts in here. There were only stipulations to the exhibits. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that she meant to do so. The defendant's intent, excuse me, may be proved by what she said, what she did, how she did it, or by any other facts and circumstances in evidence. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and the evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer or lawyers representative, that is, talk to one of the witnesses. There is nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You have heard testimony from a witness who is a police officer or witnesses who are police officers. The testimony of those police officers is to be judged by the same standards you would evaluate the testimony of any other witness. The elements of the crime charged of assault or assault and battery. The defendant is charged with the crime of assault and battery. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant, Jada Otis, committed a battery upon Kiana Smith. A battery is a forceful, violent, or offensive touching of the person or something closely connected with the person of another. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Kiana Smith's will. It does not matter whether the touching caused an injury. Second, that the defendant intended either to commit the battery upon Kiana Smith or to make Kiana Smith reasonably fear an immediate battery. A definition of force and violence as used in these instructions. The words force and violence means any use of physical force against another person so as to harm or embarrass him or her. For a battery to occur, the touching must have been intended by the defendant, that is not accidental, and it must have been against Kiana Smith's will. It does not matter whether the touching caused an injury. An assault does not have to cause an actual injury. However, if there was an injury, you may consider the injury with the other evidence in determining whether there was an assault. That concludes our instructions. I am going to release one of you to go home because you were the alternate. And barring any unforeseen circumstance, you will not be called back. Can you draw a number, please? Juror number 7. You just seem way too excited about that. I'm sorry to disappoint you that you won't be able to go and deliberate, but in case you stay on standby in case we need you. You can report back to administration for further instructions, and you should also receive your payment for today. The remainder of you will be excused into the custody and care of my court officer, and you will choose your foreperson, and you'll then be able to begin your deliberations. If you want to see any of the reference documents, which are the exhibits, you will put it on a note, knock on the door. You don't communicate, you cannot speak with my court officer directly. You would hand her the note and she will get it to the court, and we'll bring you back in here for that purpose. If you have any other questions, you'll follow the same process. Raise your right hand. You solemnly swear that you will, to the utmost of your ability, keep the person sworn as jurors in this trial from separating from each other, and that you will not suffer any communication to be made to them or of them, orally or otherwise, until the time that they are discharged. So help you God. Okay, you may be excused. Okay, this case is in recess until the time that we have either a question or a verdict. So please stay close by, not to leave the building. Thank you. I'm going to call another matter though. Counsel for Cox.
Yes, Your Honor.
Mr. Wells, are you there?
Yep, I'm still here. Can you hear me?
Right. Thank you. So you met with him already. I can hear you, sir. You met with him already?
Not, Your Honor. And today is a writ hearing.
Into my video thing. I'm trying to turn the video part of it on. The host is actually.
Okay, my notes record only reflect that we had a pre-trial. It looks like the hearing was originally scheduled for the August 14th. That happened on August 14th.
Judge, there was a judgment that entered by consent on August 7th. And we have thereafter requested the order of eviction. So today is the hearing on the order of eviction, I believe.
Hey. Mm-mm. Come here. Go upstairs and watch it. For just a second. Go upstairs. Watch it. I know, don't put bottom lip out. I come right back at you.
Sir, can you mute your device while I'm navigating, trying to go through or pull up your file electronically?
Yes, no problem.
Thank you. It won't let me click on it. That's the issue. Okay, there was an application for eviction. Let's see. Let me call the case on the record in the matter of Briar Club Apartments and Townhomes versus Darion Wells and all other occupants. This is file number 2403670 LT. Appearance for the record, counsel.
Good morning, Judge. Jen Wilburn, P 83143 for plaintiff.
Okay, Mr. Wells is present via Zoom. Mr. Wells, you can remove your hood. We're in court. And you can unmute your device now.
Okay, I'm sorry. I can hear you now.
Okay, today was the date that was scheduled for hearing. The reason why it was scheduled for hearing is there was a application in order for eviction. And the judgment was for the amount of $4,663.98. The writ indicated that the defendant had paid $3,200. And so the complete balance has not been paid still.
That's correct, Your Honor. There has been an additional payment made. However, it still does not satisfy. In total, $4,100 of the judgment amount has been made, leaving over $500 outstanding, plus additional rent that has come due since then.
Okay, so the additional rent does not apply on this rent.
Correct.
So you did not make payment according to the agreement, sir?
No, ma'am.
Okay, and so you don't have a defense as to why you didn't make the payment in full?
No, I'm actually going to be surrendering the unit, so I need to find out the time frame or whatever I need to remove all the items from the home. I've not been living there, so I'm not in town to like live in the unit, so that's why I'm not making the payments currently. So I was trying. I told the office that as well, that I don't live in town currently. I drive out of town.
Okay, well, the writ will be granted. I'll sign and date their request for today, and you can contact their attorney to they'll find or provide you information as to how quickly or how much time you'll have before they go in and remove any of your things and secure the property. But the writ will be granted. The writ will be granted today.
Okay, so contact the attorney and see how much time that I have. Is there a number that I can get for the attorney?
Mr. Wells, I would actually encourage you to reach out to your landlord to see if they are willing to hold off a little bit on execution. So talk to Kim about it.
Okay, I spoke with her the other day. I'll call her again. I appreciate it. I'll call her again right now when we all get off the phone.
Absolutely.
Okay, do you have any questions for the court today, sir?
No, if I don't have any questions for the court, I apologize.
Okay, you're all set. Thank you.
Okay,
Thank you, Judge.
am I all
Same
set
to you.
to connect or?
You're all set to go, sir.
Oh, okay, thank you.
You're welcome.
Bye-bye.
Yes.
Am I free to go?
Free to go where? Aren't you supervising him?
I am. I thought we're done.
We don't have a verdict.
Oh, Judge.
I didn't make you supervise him. You better call your job. I didn't. If it was up to me, he doesn't need supervision.
Nobody wants to supervise. me.
It's
I don't know what
unnecessary.
it is, you know? No, it is.
But it's per statute. So if you want to find someone else that wants to come and tag team for you for lunch, I don't know. But I didn't make the rule, and I didn't send you over here either. So I can't release you.
Judge. Fine.
The jury could come right now and say they have a question. What I'm supposed to do?
Okay.
Are we gonna be taking a lunch break with the jury? Or if they're still deliberating, I guess.
Let's see how long, like, I don't know if, because yesterday they may need to see your exhibits in just a moment, so let me have 15 minutes,
Right, yeah, no worries.
16 minutes.
No
If
worries.
they don't have any questions, then I'll let you have a lunch.
No worries, Judge.
Let me
I
see
figured
here.
when you made 12:30.
Why is this not letting me put a note in here? Oh, probably because I have to close this. No, is that why? No, that's not it. It won't let me complete the hearing or anything.
Your Honor, do we have to wait till after the ruling also?
No, I'm just trying to put a note in this file and then I'm going to call your case. But I can't even get to your file until on base lets me know. What did I do, Abby? What is the problem? They won't even let me say like they're incomplete. Okay, let me see. I'm still at work. Oh, wait, it's complete here. Inbox. This is Berkshire, what's the name of this? I don't know what happened to the file. What was it? It's not. Which Berkshire versus Fernandez? Press here incomplete because it's not in there. I see the I'm hearing complete.
No, on, in the bench. It's the, well, on mine, it's right under the Hunter
Refresh.
financial.
It's not showing on mine, see? I have Hunter and then it goes straight to my 130 cases. Long day stuff. Birds. Oh, maybe because it doesn't have my name where it's supposed to, I don't know, I see it here. I had to take my name off, it's, my name is not in hearing officer, that's why. Let's see. Yeah, okay, I had to, search under magistrate, no more stuff. For whatever reason. It's weird. Weird.
fuck out the car, bitch. You on live, get the fuck out that car. Get out that car, bitch, yeah. Come on. Come on.
We want you, dog.
Come on, get out the car, Bookie. Come on. Come on. Come on. Come on. Come on.
This scary ass bitch. Hit it, bitch. Let's go.
Get in the car. Get in the car. Get in the car. Get in the car. Come on, bitch. Come get out the car. Get out the car.
Bitch, you're scary as fuck.
Oh, let me reverse this. Where's that? Right there.
Get right. Oh, she's trying to crash into it.
Stupid. Bitch, you better not hit my motherfucking car.
Hit it, please
Bitch,
hit
you
it.
better not hit my motherfucking car.
Get out, Kim.
Ain't nobody gonna jump you.
No one jumping you, Bookie. Ain't nobody jumping you. Come on. Come on. Ain't nobody jumping you, bitch. Get the fuck out the car. Get the fuck out the car.
Ain't nobody gonna jump you, Bookie. Come on. Ain't nobody
Ain't nobody finna jump your weak ass, bitch. You're nobody to jump. You're nobody to jump, bitch. Get the fuck out the car.
Oh my God. You want me to stay in the car? Nobody gotta jump you.
What's something I can throw at that shit?
Ain't nobody car. Don't ain't nobody car. I want that shit mine.
Okay.
Hold on, I'm about to move though. Close that door. Close that door.
Bitch just thought shit was sweet.
Like, damn, bro. Ain't no bitch gonna come out and do shit to your touch. Yeah, this we're for sure gonna fucking fight. And I cannot wait. And don't call fucking police. Classy nails.
What they just say about me?
That wasn't you. Probably just let it play.
Ain't no motherfucking game around this hoe.
So it don't end again.
Hi, Hossy. Hossy. You want me for you? Oh, you want me for right, bro? I swear to God. It's not on me. It's in me, bitch. I can't help it, especially in a situation like this. Because the hoe is really calling me out. Like, the hoe is really calling me out. That is so fucking cute and sexy. It make my pussy wet. It make my
You ain't got me
pussy wet.
embarrassed.
It make my pussy wet. The fuck?
It's a darn bitch, you ain't me for real.
Hi, Champagne. I don't think you like me, though.
The nigga say you need
Hi,
church.
Pignon. Hi, Nana. I know you girl, but you cute. Then this hoe really be mad because I be liking her and all her friend pictures. Like, damn, bitch, I thought I really nice picture. Bitch, this is cute. The fuck? It was just cute. The fuck? Like, hoes be hoes.
Is that how to want? Did she say how to want?
No, they talking about somebody else.
I'm sorry.
I'm good.
Look at my face.
Oh, hell yeah. She right here. Here we go. Here we go. Here we go.
So the one after this would be.
Please shut the fuck up right now.
Man, bro, I think I fucking deleted it when I ended the line. This one's only 3 minutes. You can hold it.
Bitch, you're not going nowhere, bitch. You ain't going nowhere.
Bro, no, she was cool right here, and that's when I brought her.
No, I tried to pull up on the video.
So she did pull up.
I'm about to shoot this hoe. I'm about to shoot this hoe.
No, I don't fucking know. We had to, the way that she came, the way that they was right there back then. No, because they know there was a courtroom.
It's how many hoes? Look at all these bitches. Look at all these bitches. Bro, I swear on my soul, I will go head to head with this bitch. Look at her. Look at her. Look at her. Look at her. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. Look, she got brass knuckles. Look at her dumb ass. She got brass knuckles. Y'all hoes is weak. You are weak as fuck, bro. You got brass knuckles. You literally got brass knuckles on. Why are you so fucking weak, bitch? Put the brass knuckles down. Now, if I was to pop these hoes, I'd be wrong, right?
I'm gonna tell you something. And that bitch took my
Now,
fucking
if I was
purse.
to pop these hoes, look at her. 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 Look at her.
Did they take
bro, I
yours?
swear to God, bro. I'm gonna get the fuck out.
They didn't.
Y'all bitches wanna jump me? That bitch is too side. That bitch is just too big. That bitch is just too big for me. She's
Your
gonna beat
car
my
open
ass.
automatically?
Paula,
Like if
you
your
got
car's
brass
on
knuckles.
That's,
You're
I'm
weak
like,
as
how the fuck
fuck.
did they get in here?
You're so weak. Now your hoes not leaving until I'm ready for y'all to leave. Until my bitches get here. Bitch, until my bitches get here. Bitch, you got brass knuckles. You weak ass hoe. Go heads up. Go heads up. Put the brass knuckles down, bitch. Put the brass knuckles down, bitch.
Oh, like I'm not finna fight you with no fucking brass knuckles.
Down, bitch.
Yeah, I came out with
Put the brass knuckles down. Put the brass
and they're
knuckles
like,
down.
fuck your baby, fuck your baby. Y'all need to get the videos off their phone too. They really have more than what we have. That Teresa Edwards, she had the whole thing.
You got thick, Kim.
Who was the one
You
with
got
the
thick. You got thick, bitch.
Jada. That's one who
You got thick.
Cause that's what Quayla, like when
That's why she had a ski on.
bitch, big ass
Girl,
face.
fucking anybody. Put the ski on so you can shoot somebody.
I wish I had my shit on because
That's not what your nigga think.
I'm funny as fuck.
Fuck these hoes, man. Now y'all finna wait till my bitch here. Y'all finna jump me, ho. Y'all finna jump me. Y'all can wait. Y'all can wait. Y'all can wait 1 second. 1 second. Y'all somebody for you, you, and you. You, and you. Y'all bitches always wanna come deep. But little old me. Y'all all wanna hop out the car. But little old me. Now you can't leave, bitch. Now you can't fucking leave, bitch.
Y'all gotta hurry because I'm
Now
gonna
you
die.
can't leave.
And I fear I'm gonna die.
Bitch, now you can't fucking leave,
But they
bitch.
was kicking your shit. Bro, I don't even
Now you can't leave. Now you can't leave. Now you can't leave.
fucking got this shit open.
Now you can't
Slide
leave.
it under my
Now you
key.
can't leave, bitch. What is this
Or
bitch
ID
talking
is.
about?
You just slide it on my vest.
And as soon as my
Thank you.
bitches get here,
And I was saying that, but y'all can see what time I called y'all because I was really fucking waiting for y'all because this is
So
exactly
you
what
good
the
with
fuck
just
it is.
Jada and middle class? So we don't need those together.
Poor Jada gotta go.
No, it sounds like they were recording it on their phone.
I don't want to get jumped. I don't want to get jumped. I don't want to get
Open up your
jumped.
car doors
I don't want to
multiple
get
times.
jumped.
The back one, Jada opened up that one. Quayla opened up that one. Jayla started hitting me from the back. Quayla
Y'all
hit me
know
from the front.
Haley's
I was in the
not gonna
passenger
fight.
seat when they first opened the door. Yes.
Talking about nobody wanted to jump.
Bro, she didn't. That's why I told them in the video. I said, y'all don't want to jump. I said, the two bitches just open up my fucking door. Like, what do y'all want to open up the door for if y'all don't want to jump? Bitch, back up.
911, what's the location of your emergency?
Canardo Gardens, these girls put up on me and they're trying to fight me.
Hang on, what's the address? What's the address?
I don't know. It's Canardo Gardens off of Willow. It's off of Waverly.
Is it 3875 Wilson?
Yeah.
Are you sure?
Please hurry. Please hurry. They have guns. Please hurry.
Do you see a gun?
Yes, they're in the car. Please hurry. They have brass knuckles and everything. Please hurry.
Okay, how many females is there?
It's 4 total. Please hurry. Please hurry. Please hurry.
And you saw a gun?
Yes, please. I don't want to die.
Okay, where are you at?
I'm in the car.
Stay on the line. I'm going to get help started that way, okay?
Please hurry.
Good. 3867 Wilson Avenue for a female with a gun. All right, what kind of car are you in?
I'm in a motherfucking Impala.
What color is your Impala?
It's black. It's my friend's car. I was sitting in my friend's car and they walked into the car.
Okay, and are they inside a car right now?
Yeah.
What kind of car are they in?
They're in a Mazda. A black Mazda.
A black a black what?
Mazda.
Mercedes?
No.
Is it a car or SUV?
Car.
Okay, and do you know these people?
You're so pretty. You're so pretty. You're so pretty.
What's your name?
My name's Tiana Smith. I'm trying to just be nice to them because, you know, I'm just trying to play it crazy.
Okay, do you know their names?
You're so pretty. That's it.
Tiana. Tiana.
That's what I said. Get the car. Get the car. Get the motherfucking car. She just hit me in my face.
Okay, are you able to get inside the vehicle and shut the door so that they can't? You're not? Tiana.
You need to hurry up. I cannot talk to you guys right now.
We have police on the way, but do you know their names?
Come on. You're not gonna gun me. Come on. You're not gonna gun me. You're not gonna gun me.
Tiana, can you separate yourself from them?
Come on, bitch. Let me bring it outside. Let's go. Okay. Psych.
Tiana.
Yo, shit. Your punches do not hurt. You weak.
Tiana, can you hear me? Hello?
That shit did not hurt.
Tiana.
Y'all not gonna gun me.
Tiana.
I didn't say y'all did. I said y'all not this to.
Tiana.
Catch me when you can.
Tiana, can you hear me? Hello?
Haley, what? Yeah, we all lay in the same bed together. Thank you. Nope.
Tiana.
Hello?
Hi, this is 911.
I don't have time to talk. I need to be worried about my safety. They keep coming up to the car.
Okay, are you able to lock the car doors so they can't get in?
I have. For some reason, they keep getting in. I don't have time to talk to you guys. Just fucking get here, please.
Police are on the way. They're on the way. I just want to make sure you're safe. Are you able to separate yourself from them?
Jury decided that they did not want to leave for lunch. They wanted to bang it out, and my understanding is that they do have a verdict. So I'm going to have them brought back in. Sir, can you let, I don't know if they can bring them. All right, for the jury. Okay, you can be seated. Okay, my understanding is that you did have a verdict. Is that, who's the foreperson actually? Okay,
Yes, we do.
you do have a verdict? Okay, could you read your verdict, please?
We find the defendant Jada Otis not guilty.
Did you want the jury polled?
Sure, yes, sir.
Okay, juror number one, is that your true and accurate verdict?
Yes.
Number two, is that your true and accurate verdict?
Yes.
And number three, is that your true and accurate verdict? Number four, is that your
Yes.
true and accurate verdict? Number five?
Yes.
And number six. Okay, I thank you for your participation. I know this was long. It's probably the longest trial I've had since I've been on the district court, because it's gone into the afternoon of the second day. And we started reasonably early, but there were a lot of witnesses, a lot of testimony. You all took your due diligence serious as you reviewed the evidence and had questions to review the evidence again, and didn't even want to take a lunch. You wanted to bang it out. So I appreciate it. And we cannot provide this level of justice without your participation. So thank you again for reporting for your duty. You're going to be released into the hands of the court officers so that you can get back to administration. You do need to pick up your payments again for today. If you want to stay back, it's up to you, but a lot of times the attorneys like to talk to the jurors and get an understanding of, you know, how they did, or feedback or evidence. So that's completely up to you. And if you'd like to do that, you can stay back in the jury room and meet with the attorneys, okay? But thank you again for your service. You can be excused. Thank you, sir. Seated. So we'll enter a acquittal by way of jury. And Ms. Otis, you should be thanking your lucky stars. This is a matter that started out as a felony and was reduced to a misdemeanor, went to jury trial, and you were successful with the not guilty. But what you weren't successful with was demonstrating character on those videos. You weren't successful there. You did not in any means present yourself the way I believe your parents raised you to be. How old are you? Are you employed?
I am.
Are you in school?
I am not.
What are your goals?
Just trying to make it.
Just trying to make it?
Yeah.
What does that mean?
I don't know yet.
Well, you probably need to get some goals, and they can't just be hanging out in cars and showing up trying to fight people. That's not demure. That's not ladylike. That's not classy. What I saw was tasteless, disgusting behavior displayed by all parties. It was disgusting. I've had to cringe multiple times. You ought to be ashamed of yourself. So I'm going to caution you to be careful about not just the company that you keep, but the character that you're portraying. And then putting it on social media like it's something to be proud about. The language that's coming out of your mouth, like you're a hoodlum. You're a young lady, conduct yourself like one. Even when people aren't watching. Do you understand that? Because you may not be so lucky next time. There's a thing called guilty by association. And it very easily as you got, I don't know how easy it was, but it could have easily have been the other way. You could have got a conviction on your record. You had your time taken up, your parents' time taken up, jurors' time taken up over some silliness, some foolishness. Be mindful about what you decide you're going to put your safety, your freedom at risk for, because nothing I heard over these last 2 days was worth it. Good luck to you. I'm going to sign, get you a copy of your acquittal, and you'll be on your way. Okay, which case are you here on? What case are you here for?
I'm here for LG Lansing and LG Apple Bailey. Cases underscore Al Osborne.
Okay, thank you. If no one's here for Trappers Cove versus
Oh, yes.
Lightfoot. Oh, I can't see you back there.
Hi.
Okay, very good. On the record in the matter of Trappers Cove versus Micaiah Lightfoot, 24-04283, council appearance.
Good afternoon, I'm Ron Fox here for plaintiff here on Development LLC, DBA Trappist Cove.
Okay, and state your name, ma'am. Okay, Ms. Lightfoot and Mr. Barker both present in the courtroom today. Was the date set for a hearing for non-payment? How are we proceeding?
Sharon, we've agreed to entry of a consent judgment. With the normal work date of 10/28/24. The rent to retain at this time $3,384.46. Cost of $170.54 for a total amount to retain $3,555. Got the same date for the appeal date 10/28/24.
Yes, please. And then that's how you want to proceed with consent judgment? Okay, you sure? Okay, so let me advise you of your rights. Because this is a judgment entered by consent where you would agree to waive such rights. So one is your right to be represented by an attorney. You understand that you have the right to be represented by an attorney? You understand that, ma'am? Is that a yes?
Yes.
You want to give up your right to be represented by an attorney in this matter? Okay. You also have the right to proceed to a trial. You could have demanded a jury trial, or you could have had a non-jury trial. At which point you could have submitted any defenses that you believe you had to why your rent has not been paid. Did you want to give up your right to have a trial? Anybody threatening you to do that? Any promises being made if you give up these rights? Okay, so you want judgment to enter by consent whereby you agree that the amount of rent owed to pay or to retain possession is $3,384.46 plus $170.54 in cost for a total of $3,555 that you'll pay that or vacate the property no later than October 28th, 2024, correct? Yes. You have 3 business days from today's date. If once you leave here, you realize that you misunderstood the rights that we just went over, you can return to the court and request to have this agreement set aside, and then we'll set it for a hearing for you to explain how you misunderstood your rights, okay? Do you have any questions? No. We'll get you a copy of this paperwork, and then you'll be all set. Any additional matters for the record today? You're all set, ma'am. On the record in the matter of LG Lansing LLC versus Sierra Nathan 24-04580, council appearance.
Victoria, I'm here for the plaintiff, LG Lansing LLC.
State your name. Sierra Nathan. Okay, today's the date that was set for hearing for non-payment of rent. Council, how are we proceeding?
Yes, Your Honor. The defendant and we agreed to enter into a conditional dismissal. I do not have a conditional dismissal filled out, but if we could put the terms on the record.
Why don't you have one filled out?
I came prepared with a judgment.
Do you want us to print you one?
Yes, please.
But what? Oh, you need 4 for all of yours. Okay, I'll let you put the terms on the record and you can file it. I'll get permission on the record then. Okay, you can put the terms on the record.
Okay, thank you. Ms. Nathan has agreed to pay normal monthly rent on time. Right now, she owes through the month of October $5,862 in past due rent and court costs and fees in the amount of $263.80. Total $6,125.80. Like I said, Ms. Nathan has agreed to pay $500 every 2 weeks in addition to paying her normal monthly rent on time. She has agreed to abide by all the terms of her lease agreement moving forward. And she understands that if she defaults on the terms of the conditional dismissal, that plaintiff can file or ask the court for apply for an order of eviction without further notice or process to her. And if she defaults on the terms, then the court should enter a possession judgment and a money judgment in the amount of that $5,757.60, which represents rent due today.
Is that accurate, ma'am?
Yes, sir.
Okay, so you want the matter to be dismissed based on those conditions today?
Yes.
So you understand that you would have to give up your right to be represented by an attorney in order to proceed this way?
Yes.
You also have the right to proceed to trial. You could have demanded a jury trial. You understand that?
Yes.
Okay, anybody threatening you to get you to give those rights up?
No, ma'am.
Any promises being made to you in exchange for giving up those rights?
No.
Okay, you have 3 business days from today's date. If once you leave here, you realize you misunderstood those rights, you can return to the court, request to have a disagreement set aside and explain how you misunderstood your rights. Lastly, because the paperwork is not being executed and she's gonna have to execute it later, are you going to give her permission to put your signature on the paperwork so long as it is consistent with the agreement stated on the record?
Yes, yes.
Okay.
It's already been stated.
I'm sorry?
I say yes, already been stated.
Okay, sounds good. Do you have any questions?
No.
Any additional matters for the record?
No, ma'am.
Okay, you're all set, ma'am.
Thank you.
On the record in the matter of the people of, I'm sorry, switch gears back. On the record of the matter of LG Lansing versus Michael Spencer, 24-04597.
Victoria Osborne for the plaintiff, LG Lansing LLC.
Please state your name, sir.
Michael Spencer.
Okay, today's the date set for a hearing. This is for non-payment of rent. Did you come to resolution?
Yes, Your Honor. Mr. Spencer has agreed to enter into a conditional dismissal. As of right now, through the month of October, the rent to retain possession is $3,455. Court costs and fees in the amount of $255.78. That totals $3,710.78. Mr. Spencer has agreed to make his normal monthly rent payments on time moving forward. In addition, he's going to pay an additional $500 on the 15th of each month until the balance is paid in full. Mr. Spencer has agreed to abide by all the terms of his lease agreement, and if he defaults on the terms of the conditional dismissal, he understands that the plaintiff will file an application for an order of eviction without further notice or process to him. If he defaults on the terms, then the court shall enter a possession judgment and a money judgment in the amount of $3,369.74. And there is one more term that I missed, and Mr. Spencer has agreed to make a $500 payment by this Friday, which is October, I believe.
Today's the 16th.
Oh,
The 18th.
the 18th. Just thank you.
No problem. Mr. Spencer, is everything she said accurate?
What was that? What was that thing on the 15th?
Well,
You said something about something on the 15th.
yep, in addition to your normal monthly rent, you're gonna pay $500 on the 15th of each month.
Well, I thought it was just every 2 weeks coinciding with the
It's every 2 weeks, but there's 30 days, and so I can word it that way if you would like.
No, it sounded like you said it, in addition to my rent, $500 as well.
On the-
Once a month, on the 15th. Is that what you
Correct.
meant?
Right, because it's 2 weeks. You're
That's
right.
2 weeks after your rent's due. Your rent's due on the 1st, sir? Is it?
Is it?
Okay, so then 2 weeks after that will be the 15th.
Okay.
And then 2 weeks
Well,
after that.
I just thought it
2
was
weeks after
every
that.
2 weeks, no matter what.
No, 2 weeks
In
after the,
addition
listen
the-
to me, listen to me.
Okay.
2 weeks, your rent's due on the 1st.
Yeah.
14 days after that, which is 2 weeks, is the 15th of the month.
Yeah.
Guess what happens 2 weeks after that?
Okay, $500.
Your rent's due again.
Right.
That's why she said the 15th.
All right, well, that's fine.
That's what she
That's
said
less
sounds
than I
better
thought I
than
was
what,
paying every week.
exactly.
Good,
That sounds
good.
better than what you were talking about,
Yeah,
actually.
yeah.
Okay. Do you have any other
Yeah.
questions? Okay, and so what she's saying is accurate as to how you want to proceed?
Yes, sir.
So that means that you would have to give up your right to be represented by an attorney today. You understood that you had the right to have an attorney represent you in this eviction matter? Okay, you want to give up your right to be represented by an attorney?
Yes, sir.
You also have the right to proceed to trial. You could have demanded a jury trial. Do you want to give up that right?
Yes.
Anybody threatening you to do that?
No.
Any promises being made if you give up these rights? Any promises being made for you
No.
to give up these rights?
Okay.
Okay. You have 3 business days from today's date. If once you leave here, you realize you misunderstood those rights, you can return to the court and request to have this agreement set aside, okay?
Yes.
And do you give her permission to sign the agreement with those terms that we placed on the record?
Yes.
Okay, any additional matters for the record, counsel?
No, thank you.
Thank you, you're all set, sir.
Thank you, Judge.
You're welcome.
Thanks, everyone.
On the record, in the matter of LG Apple Bailey versus Larry Trevino. This is 24-04598.
Victoria Osborne for the plaintiff, Your Honor.
What's your name, sir?
Larry Trevino.
Okay, this is a hearing today for non-payment of rent. How are the parties gonna move forward?
Yes, Your Honor, we have come to an agreement and agreed to enter into a conditional dismissal with the following terms. Mr. Trevino agrees to pay his normal monthly rent on time moving forward. He also agrees to abide by all the terms of his lease agreement. He agrees to pay a payment of $200 by 10/18. In addition to his normal monthly rent, he's gonna pay an additional $500 on the 15th of each month until his payment is made in full. The rent to retain possession is $1,623. Court costs and fees in the amount of $229.61. That totals $1,852.61. Default on the terms of this conditional dismissal shall result in a possession judgment and a money judgment in that full amount.
Mr. Trevino, that's accurate as to how you want to proceed?
Yes.
Okay, you understand that you have the right to have an attorney represent you?
Yes.
Are you waiving that right? You have the right to have a jury trial or a non-jury trial in this matter. Are you waiving that right?
Yes.
Anybody threatening you to do that?
No.
Okay, you have 3 business days from today's date to return to the court to request to have this set aside. If you leave here and realize you did in fact misunderstood those rights that you have just waived. Lastly, do you give her permission to assign your name to an agreement or conditional dismissal that meets the conditions she put on the record?
Yes.
Okay. You have any questions? Any additional matters for the record?
No, thank you, Your Honor.
Okay, you're all set. You had another one ready?
Yes, Your Honor. Apple Bailey versus Andre Springle.
Okay, file number 24-04600, council appearance.
Victoria Osborne for the plaintiff.
So what's your name?
Andre.
Okay, today's date's up for hearing. This is for non-payment of rent. Council, we proceeding.
Yes, I've had the opportunity to speak with Mr. Pringle, and we have agreed to the terms. We have agreed to enter into a conditional dismissal with the following terms. The rent to retain possession is $8,875. Court costs and fees in the amount of $220.61, which totals $1,095.61. Mr. Pringle has agreed to make rent payments on time moving forward. In addition to his normal monthly rent, he's gonna pay $155 per month. So that will be a total payment of $200 due on the 1st of each, or the 5th. It will be late if it's not due on the 5th of each month. He's agreed to abide by all terms of his lease agreement, and default on this conditional dismissal shall result in a possession judgment and a money judgment in the same amount. And any third, Mr. Pringle has applied for assistance, so any third party contributions towards his rent shall deduct from the total.
That's accurate, sir?
Yes, ma'am.
Okay, you sound surprised when she said the amount. Why?
8,000.
You didn't know?
8,000, I didn't, I wasn't.
Well, how did you enter into agreement and you didn't know what the amount was?
It was 800, she got it misconstrued.
800?
Yeah, it
Oh.
was 800, it was, she said 8,000.
Oh, that's what you were shocked at?
Yeah.
Okay,
Yeah.
okay. But you just were shocked, not, you weren't like, no, that's
I
not
was
it.
shocked, 8,000, I
Okay.
was like, well, I stay at Hughes, Rich.
I would agree,
Yeah.
but listen, I can tell you one thing, we've definitely seen it come through here and it's not the Hilton. It's just people who have gone so long without paying. So with the amount she corrected herself with, you're okay, that's your agreement, that's your understanding, no
Yes, ma'am.
dispute there, correct? Okay, and you understand your right to be represented by an attorney?
Yeah.
You want to give up that right?
Yeah.
You also have a right to proceed to a trial. You could have made a demand for a jury trial.
Yes.
You want to give up that right?
Yes.
Is anybody threatening you to get you to give these rights up?
No.
Any promises being made to you?
No.
Okay. You have 3 business days from today's date. If once you leave here, you realize, you know what, I didn't understand those rights. You can return to the court, request to have this agreement set aside, and then we'll set it for a hearing for you to explain to us how it was that you misunderstood your rights, okay? You have a question?
No, ma'am.
Okay. Lastly, do you give her permission to sign the conditional dismissal with the terms she placed on the record?
Yes.
Okay. Any additional matters, counsel?
No, Your Honor, thank you.
Thank you.
So that'd be 215, right? 200 that we're talking about, ain't no. I mean, the 5th, okay, yeah, all right, I got you. All right,
Okay, thank you.
Yep, bless that.
Same to you.
Yeah.
Did
I
Cameron,
apologize, Your Honor, I will bring conditional dismissals next time.
no problem. Is Cameron Eck up here?
Oh, Your Honor, I filed a dismissal on that matter. this
Oh,
morning.
okay, sounds good. You filed a dismissal this morning?
Yes,
So that's all you have today?
that is all I have.
Okay, thank you.
Thank you.
Mr. Palmer's attorney. Anthony Palmer. Yeah. I know. One second.
on the record in the matter of Body Inc. versus Mark Gibson and Amy Nichols Gibson, 24-044604, council appearance.
Good afternoon, Your Honor. Nicholas Darling House appearing on behalf of Body
Okay, your name, ma'am?
Amy Nichols Gibson.
And your name?
Mark Gibson, yeah.
Okay, thank you. Today was the date that was scheduled for a hearing for termination of tenancy. And the parties were able to come to resolution or no?
Yes, Your Honor.
Okay.
Yes, we have terms for a conditional dismissal, Your Honor, and pretty simple and straightforward. It's just that tenants agree that they will vacate the premises on or before October 30th, 2024, or a written aid may be entered. Yeah, approach.
Oh, you may. That's how you all want to proceed?
Yes, ma'am.
Okay, so you have the right in this matter to be represented by an attorney. You understood that, right?
Yes, ma'am.
You want to waive it?
Yes.
You had the right to proceed to trial. You could have demanded a jury trial, at which time you could have presented any defenses to this eviction. You want to waive that?
Yes.
Anybody threatening you to do that?
No, ma'am.
Any promises being made to you to give these rights up?
No, ma'am.
So you're willing to vacate the property by October 30th?
Yes, ma'am.
Turn over the keys by that date. It says that you'll vacate the premises before then, and that the case will be dismissed today upon that condition, correct?
Yes, ma'am.
You have 3 business days from today's date. If once you leave here, if you realize you misunderstood those rights, you can return to the court, request to have this set aside, and we'll set it for hearing, okay?
Yes, ma'am. Thank you.
No problem. We'll get you a copy of the dismissal in just a moment.
Hey, like your hair, man.
Thank you.
Thank you, Your Honor. Have a good afternoon.
You too. On the record in the matter of Tate Raw LLC versus Anthony Palmer, 24-04665, council appearance.
Good afternoon, Your Honor. Elijah Tyra, P 86242 on behalf of defendant, Mr. Anthony Paul.
Okay, today was the date that was set for a hearing for non-payment of rent. It's scheduled for 2:30. It's 2:48. I don't have anybody here on behalf of Tay Raw LLC. And you all have not completed any negotiations or resolution, I should say.
We did come up with conditional dismissal, but since they're not here, I'm asking them before
Motion to dismiss is granted. Thank you. You're all set. Well, I will do it. There's a lot of spirited activity happening over there. Like, what is going on?
Sounds like we have a
I
party.
mean, are these arraignments? Maybe we should have set those arraignments. What's that for? For this one? Okay. On the record in the matter of 900 Long versus Kayla Horton, 24-04787, council appearance.
Okay, actually, Madam Record, on behalf of plaintiff.
Elijah Tyra, P 86242. On behalf of the court.
Okay, Ms. Horton has a consent order of conditional dismissal negotiated here. And so since the defendant agrees to vacate the premises at 900 Long Boulevard, apartment 265, Lansing, Michigan, either on or before November 8th, 2024, defendant shall return the keys to the front office before the close of business that day. And under that condition, the case will be dismissed today. Is that accurate? Okay, and so you understood your right to proceed to trial on this matter?
Yes, ma'am.
You understand that by giving that up, you also give up your right to make any counterclaims or present defenses?
Yes, ma'am.
Okay, we also understand that partial performance of this will not satisfy this, so you have to get all of your stuff out on or before the 8th of November and turn over the keys. You understand that? You have any questions? Okay, you have 3 business days from today's date. If once you leave here, you realize you misunderstood those rights, you can return to the court and request to have this agreement set aside, okay? We'll get you a copy and you'll be all set. Any additional matters for the record? You're all set. Thank you. You said West and Thomas in here? Yes. Okay, on the record in the matter of 900 Long versus Mariah West and Calvin Thomas, 24-04785.
Yeah.
Sir,
Calvin Thomas.
your name, ma'am?
Mariah West.
Okay, today is the date that was scheduled for hearing. How are we proceeding on it? How are we proceeding for this?
If I may, check the consent judgment.
Okay, so this matter is going to be resolved by entering consent judgment. That's how you want to proceed? Okay, so you want judgment to enter in the amount of rent to retain $6,783.02 plus court costs, $216.93 for a total amount to retain possession, $6,999.95, that you'll either pay that amount or vacate the premise at 900 Long Boulevard, apartment 258 by October 28th, 2024, correct? Okay. Both of your signatures are here. I need to hear it on the record. Thank you. You understand that you have the right to be represented by an attorney? Okay, you want to give up your right to be represented by an attorney?
Will it be like another court date after this?
If you didn't give up your right, you can't do this. You would have to get another court date so you can go hire an attorney. You would have to hire an attorney. There's no court appointed counsel for this purpose.
No, that's fine.
You want to give up your right to attorney?
Yeah.
Okay, you also have the right to proceed to trial. You could have demanded a jury trial. You understood that right? You want to give that right up today? Anybody threatening you all to give these rights up? Okay, you have 3 business days from today's date. If once you leave here, you realize you misunderstood your rights, you can return to the court, request to have this judgment set aside, and we'll set it for hearing. We'll get you a copy in just a moment. Any additional matters for the record, counsel? You're all set. It was already dismissed. I just don't- it might be a little bit- oh, right here.
I was just wondering if you're hiring. Is it much better work?
I'm sorry?
I was just wondering if you're hiring.
Oh,
It's
gosh.
better than my work environment,
Oh.
where they just talk about golf, it's all men.
Well, it's the nature of the private practice, isn't it?
Yeah.
I suppose.
It's like-
It's where the deals are made.
Yeah.
Let's see, on the record, in the matter of 900 Long versus Kinticia, here is 24-04824, council appearance.
Lord, we honor on behalf of plaintiff.
Please state your name. Okay, today was the date that was set for the hearing. How are we proceeding on that?
Your Honor, if I may approach, I have a consent.
Yes. I think I just accidentally did the wrong one. Oh my. Okay, let's see. Yes, there we go. Okay, so I have a consent judgment. That's how you want to proceed on this? So judgment will enter by consent whereby you agree that the past due rent to retain possession is due in the amount of $6,315.03, plus court costs of $193.54 for a total amount $6,508.57. That you'll pay that amount in full or vacate the property of 900 Long Boulevard, apartment 357, no later than October 28th, correct? Okay, and you understand that you had a right to be represented by an attorney?
Yes.
You want to waive that right?
Yes, ma'am.
You also have the right to proceed to trial. You could have demanded a jury trial. Do you understand that?
Yes, ma'am.
And you wish to give up all of those rights today?
Yes.
Okay, you have 3 business days from today's date. If once you leave here, you realize you misunderstood those rights, you can return, let the court know that you want to set this judgment aside, and you'll explain how you misunderstood your rights, okay?
Yes.
We'll get you a copy in just a moment. Any additional matters for the record? Thank you. I accidentally completed Clayton and on base, and I thought I was clearing out Cage. Okay, did I? I didn't see anybody here but Colette versus on Crosby, and then let's see, Cage was dismissed. And what happened with Chapman?
I didn't see it. She was at 2:45.
Oh, Chapman's didn't appear?
Right.
Okay, you can submit default. Thank you. That's the default. Let's see. Mr. Tyler leave?
No, he's here. We
Does he have one more? I
Yeah,
thought he was gonna
3:30.
say.
The rest are, I believe, I have 2 more there at 3:30, so I'm gonna obviously have to wait.
Yeah, Clayton and Wilson, okay, and then Crosby, I don't know where, I didn't see anybody here for FR Lansing today. Where did I see one for Crosby? You. on the record in the matter of 900 Long versus Alexandra Wilson. This is 24-04833. Council.
Clark, who's here on behalf of Keisha?
Elijah Tyree, 86242 on behalf of defendant.
Okay, and then Mr. Wilson is present in the courtroom. I have a consent order for conditional dismissal. It states here that the defendant agrees to vacate the premises of 900 Long Boulevard, apartment 259, on or before November 8th. And the defendant shall turn over the keys to the front office by the close of business on that date. And upon that condition, the case will be dismissed today. Is that accurate?
Yes.
Why is he standing and not you? Thank
I
you.
told him to sit down. That was on me. That's not.
Thank you. Okay, and that's how you want to proceed, Mr. Wilson?
Yes.
Okay, so you understand that you had the right to proceed to trial in this matter? You want to give up your right to a trial?
I'm sorry.
Do you want to give up your right to a trial, or do you want to have a trial? Okay, no, you don't want to have a trial?
No, I don't.
Okay, very good. Okay, you understand that? No problem. I realize I asked you two questions. You understand that partial performance will not satisfy this. That means you gotta get all your stuff out and turn over the key by the 8th. You understand that? Okay, you have 3 business days from today's date. If once you leave here, you realize that you misunderstood your right that you gave up, you can return to the court and request to have this set aside, and we'll set it for hearing, okay? We'll get you a copy in just a moment. Any additional matters for the record?
Thank you.
You're all set.
You just have one more, but it's at 3:30, so I'll wait for her. Thank you. If you have any questions or anything, I'll just leave you. Have a good day.
You too.